May please, Lordship. I am praying for listing of GST matters for motion, my lord, tomorrow. The Lordship has already passed similar orders and matters are pending on 18 is fixed, my lord. On 18 matters are fixed, my lord. The Lordship has passed similar orders in other matters granting interim relief, my lord.
What kind of?
My lord, notification was challenged, my lord.
Huh?
Notification extending limitation was challenged, my lord. And Lordship has passed some orders, my lord. Tomorrow, my lord.
May I please, Lordship? My lord, on motion matter, my lord, the identical issue has been challenged before this honorable court that is fixed on, my lord, 4th of March. May I pray, my lord, this matter may be posted
4th of March.
4th of March, my lord.
May please, your lordship. I pray for
Motion.
Motion.
I
And
pray-
another, my lord, admission matter, my lord. Can it be next week, my lord? Any
No, make a mention in the next week.
registry, my lord?
Make a mention in the next week or registry.
Oblige, Lordship.
Well, this is also for admission. Well, this matter was listed twice in consecutive that it was not reached. Well, there is an urgency. Well, admission matter.
What
Any day,
urgency?
matter. Not here. What happened? Well, we have challenged the order passed by the registrar, handing over the charge of a cooperative society to a person who was.
Next week admission.
Highly obliged.
May I please, your lordship, item 13, lordship, today's list. Lordship, the petitioner has got the relief that may be closed, lordship.
Okay. Mr.
Miss,
A. Talukdar, Ms. A. Talukdar, learned counsel for the petitioner, has submitted that as the petitioner has got the relief during the pendency of the petition, the petitioner does not want to pursue the petition. Any first counsel? Okay. In view of the above submission made by Ms. Talukdar, learned counsel for the petition, the petition is dismissed as not placed.
much obliged.
May it please the lordship, I beg to mention item number 1 to 7 of the list, my lord. My lord, can the arguing counsel, the senior counsel will be in on legs in isol bench, my lord. Can the matter be fixed at 2, my lord, if your lordship?
Well, in that case, on 12th of March, madam, I've taken the.
We
We are supposed to
Mr.
give the-
Gogoi, there is some difficulty. I don't think I'll be continuing with this roster.
No, it's a part.
Possibility roster will be changed.
It's a part matter.
That is, and then thereafter, difficult.
Tomorrow
Tomorrow again, I will be rising, Mr. Swagia, early. There is tribunal matter, Tripura tribunal matter. I'll be rising in the second half. And first half, there are motions,
Motions will be there.
many
Lordship
motions.
is available next week, lordship, on Monday.
Monday, but it will be a different roster altogether.
As if because it is a part
And
matter
thereafter,
on Tuesday, it's a part matter, lord.
because I don't know what the roster will be.
Lordship.
Formal shall be mentioned in the next week, considering the roster, we will make a mention on a convenient date to this honorable court as well as the Rani senior. Any day, madam, on Monday.
Because I'm also uncertain.
Yes, let the matter be adjourned only for the day.
Only for the day in that case. We'll make a mention on Monday, madam, if this court is available.
Okay, 1, 2.
1 to 7.
Okay, Mr.
B. Sharma, my lord, on
P. Sharma. Because I did not fix any other matter because of this.
There is actually very urgent series matter from item 6 in another court. That's why our medical college work has been hampered, lordship.
Mr. P. Sharma, learned counsel. Appealing for Mr. Dr. A. Saraf,
Sharma, my lord.
learned senior counsel for the petitioners. One has submitted that Mr. Dr. Saraf is not available due to emergent personal reason.
I don't know.
That I cannot. Just because you are busy in Aizol bench, I cannot. Emergent personal reason. And has sought for an adjournment. Mr. D. Hoikia, learned Advocate General Assam, assisted by Mr. Dr. or Mr. B. Gogoi, learned Standing Counsel, Finance and Taxation Department is present, and has submitted that. Mr. Hoikia has submitted that in view of the region cited, he has no objection to the prayer. The cases be listed. I want to give order to Kalipas. Let me see the roster
Yes,
by evening.
yes, Lordship. Lordship.
Then
Accordingly, Lordship, maybe only things that from 7th I am not available. 4th, 5th, 6th, all days I am available, Lordship.
7 till
7th is on only day I am not available. Then on 16th, 15th I will not available like that. Lordship, 5 to 7 also my Dr. Sharaf will be unavailable. 5 to 7th, 5, 6 and 7 Dr. Sharaf also would be unavailable, my lord.
unavailable.
5 to 7. 11th I am available, Lordship. 11th till 14th I am available. 15th I am not available.
Basically, that means 11 to 14.
11th to 15th I have a NGT matter, Lordship. That's all. 14th.
Thereafter, I will not be available.
Lordship.
For 2 weeks, I will not be available.
From 16th onwards. Obliged, my lord.
So,
12, 13, Lordship's
13,
convenience.
14, we'll
Yes,
see.
Lordship.
Date to Rakito.
Obliged, my lord. Deeply obliged.
May I please, Your Lordship? I beg to mention item number 14 and 15.
Yes.
I will be allowed to withdraw this matter with liberty.
Why after 6 years liberty?
Lordship,
If any new cause of action, you come.
Lordship.
In the event of new cause of actions, right? MSP Bora, Learned Counsel, appearing for the petitioners, has submitted that the petitioners want to withdraw the writ petition, with their liberty, writ petitions with their liberty to approach again in the event of
Lordship.
any new cause of action. Mr. S. Borua, Learned Junior Criminal Advocate Assam for the state respondents, who is in attendance, has submitted that he has no objection as regards the prayer for withdrawal. In view of the above submission made by MS Bora, Learned Counsel for the petitioners, the petitions separately is dismissed on withdrawal, with their liberty as prayed for.
Lordship. Obliged.
For motion item number 18.
May it please, Your Lordship. The petitioner before Your Lordship is a society under the Societies Registration Act, and they are liable to pay service taxes under the Finance Act. So there was a default of payment from 2013 to 2017. But there was no so-called notice regarding that at that point of time. However, in the year 2019, the central government under the Finance Act launched a scheme, which Lordship will find at page 55. Sabka Biswas Legacy Dispute Resolution Scheme 2019, Section 120. This scheme was launched wherever there are certain conditions where people who feels that they want to give the taxes where there is a dispute or there is a due, then they can avail this scheme. Section 125, Lordship will find at page 59. All persons shall be eligible to make a declaration under this scheme except the following. So certain category of persons are excluded from this scheme. However, Assam Cricket Association has fulfilled all the eligibility criteria. They, as a good taxpayer, Lordship, bona fide citizen, legal citizen, Lordship, decided that they will disclose whatever is due for the period 2014 to 2017. And made an application as per the procedures laid down under the Act as well as the rules framed thereunder. And the authorities also duly examined everything and finally issued the necessary certificates, which Lordship will find at page 168. Only 68. So first we have to fill up a form called Form SVL DRS 1. Where we have to declare under Section 125, read with Rule 3 of the scheme 2019. So we declared that we have a due of more than 6 crores something. So they examined it and they issued a certificate from their side. Yes, they agreed to our declaration and they did not find any flaw in our calculation. This is a self-assessment, Lordship. And accordingly, we decided that we'll give the amount. They issued this that by 30th of March 2020, 30th of March 2020, page 83. Sorry, page 72, they have issued that certificate. They issued a certificate, Lordship will find that at page 71. So we submitted the form SDLVS 1 at page 70. Our declaration is, Lordship, amount is 6 crores 46 lakhs 39,056 rupees. Lordship will find at serial number 1, amount, details of duty. Have Lordship got it? Page 70. This is our declaration, Assam Cricket Association's declaration. And after verification, they issued the form, page 71, Annexer E, as VLDRS 3 form. So, Lordship will kindly see the category serial number 1, voluntary disclosure, taxability of service, period 1/10/2014 to 36/2017. Amount is so and so for 6 lakhs 46, that odd amount, and they have estimated amount payable. Last column, last 6 lakhs 46. So they did not dispute our disclosure amount. And in response to that, Lordship, immediately we generated the challan at page 72. So mandate form, it was generated, account number so and so, RBI, virtual IFSC, challan expiry date 30th March 2020. Time is also given, total duty amount 6 crores 46, that amount. So that challan also Assam Cricket Association has generated. And the last time of submitting it is 30th March 2020. Lordship remembers on 24th of March, the lockdown was declared in the country. It is a part of the record also. And Assam Cricket Association failed to do it on that day. In the last week of March, it was decided to submit the amount, to deposit the amount. But already at the instance of Assam Cricket, this challan was generated. It was generated about 2 weeks earlier. Then, second challan also we have, because lockdown was imposed, and therefore the authorities extended the time for submitting the deposit to 30th June. Page 73. Then another challan was generated by Assam Cricket Association, where Lordship will say challan expiry date 30th June 2020, 12 AM. In the meantime, Lordship, page 74, for June, then in Assam, there are certain containment zones were declared during the same phase. And page 76, Lordship will see, we have the time till 30th June. So on before 30th June, we have to deposit. On 23rd June 2020, page 76, the District Assam State Disaster Management Authority, they issued an order where that serial number, Bhaskar Nagar, Borsapara, Dhirenpara, etc. were declared as containment zone. So no person can enter there. May I read this order? It has been reported to me by District Magistrate Kamrup that there is large scale spread of COVID-19 affected areas among the general public of certain areas of Guwahati city, which has posed as a major threat to public health, hygiene, and safety of the general population. I therefore, in my capacity as chairman of the State Executive Committee of the Assam Disaster Management Authority, in exercise of power conferred under Section 22(2)(h) of the Disaster Management Act 2005, do hereby issue directives to the Commissioner of Police City, District Magistrate Kamrup,
to enforce total lockdown in the areas given below. This order shall come into force with effect from 9 p.m. of 23rd June and shall remain in force until further orders. Indefinite lockdown has been declared in Borsapara, where the Assam Cricket Association's office is located. Then prohibition activities, page 77, and there are certain exceptions. Bank is exempted, but we do not fall under the category of banks. So prohibited areas, all offices, serial number 2, all government offices, offices of autonomous subordinate offices, private offices shall remain closed. So indefinitely that State Cricket Association's office was also closed. It comes under the purview of this notification. And thereafter, there was no extension from their side. Now, we submitted a representation to them. Because once 30th June was over, we wanted to go and deposit the amount when the lockdown was lifted. The system was not accepting our amount. So we wrote a letter on 15th of March 2021 to the Principal Commissioner, State Central Goods and Service Tax, Guwahati, request for opening of window to allow payment of taxes payable under SBLDS 3 dated 29/2/2020. In reference to the above, we would like to inform you that we have opted for the Sabka Vishwas Legacy Dispute Resolution Scheme, and we have declared an amount of 6 crores 46 lakhs, etc., against which the designated committee had issued us SBLDRS. The committee examined and issued this number so and so on 29 February 2020. In this regard, we would like to inform you that the due date for payment of taxes under the scheme was originally 30 days from the date of issue of SBLDRS 3, and same was later extended to 30th June 2020 due to COVID-19 pandemic. However, we have duly generated the Salan mandate of so-and-so tax payment on 12/3/2020, which was valid till 31st March 2020, but we were unable to deposit the amount to the government exchequer due to declaration of first phase of lockdown of COVID-19 pandemic in the state of Assam. That was on 24th of March for the whole country, actually. We have generated the Salan mandate on 7/5/2020 again, which was valid up to 30th June 2020, when the partial relaxation was declared by government notification dated 1/6/2020 in the district of Kamrup Metro. However, declaration of the second and third phases of lockdown for prevailing COVID-19 pandemic, government notification dated 23/6/2020, which I have just read out, have compelled us to fail the compliance once again, as we are unable to make the payment to the exchequer. So all the documents we have submitted. Please note that once the lockdown is lifted, we have made number of attempts to create a fresh challan mandate from CBISC SBLDRS portal. However, we found that the payment window is closed in the SBLDRS portal. As such, we have approached the departmental officers to guide us in this regard and allow us the opportunity to make the SBLDRS payment. However, despite of desirability to pay and availability of fund reserved for the purpose, we are unable to deposit the said amount to the government exchequer due to the reasons mentioned above. In view of above, we would like to intimate you that as an honest taxpayer, we are willing to pay the tax amount as declared in our SBLDRS 2019 declaration and request us to instruct the appropriate procedure to deposit the same. Till date, there is no response to this. In the meantime, Lordship, what we have done, we keep on trying. Then on 31st August 2022, page 83, under the normal system, we generated another challan. It was generated on 16th August, where of 2022, challan expiry date 31st August 2022. We generated, and on the next date, Lordship, we deposited the whole amount under the normal channel. So in 2020, 22 payment. Then on 18/8/2022, page 84, we informed them. The Principal Commissioner, Central GST, intimation of deposit of tax payable against SVLDRS 3 dated 29/2/2020. Our bona fide is here that in spite of not getting any response, we deposited it. We did not keep the money. First is a narration of the same, page 85, the penultimate paragraph. We have duly intimated above troublesome in making the requisite payment and requested the department to instruct us the appropriate procedure to deposit the same by letter dated 15/3/2021, which was duly acknowledged by your good office on 17/3/2021. However, till date, we have not received any communications from the department. Hence, we have generated the Salan mandate amounting to 6 crores 46 lakhs so and so on 16/8/2022 by regular procedure of depositing service tax to the government exchequer and deposited the same on 18/8/2022. We deposited the amount. We shall be highly obliged and thankful for your appropriate initiative for issuing the SVLDRS 4 in this regard for appropriating the above said deposit made by us. So in 2022 itself, we deposited and we requested for the discharge certificate under SV that form 4, which they have not done, but we have not pursued it further because we have completed our part. That certificate they should issue, we should have actually come before this court that they have not issued. In the meantime, we deposited in August 2022. On 1st November 2022, they issued a show cause notice now, which Lordship will find at page 87. Demand comes show cause notice. Whereas it appears that Assam Cricket Association so and so, all this thing. If Lordship's paper is visible, eligible,
Not very.
then we have a page.
Okay, readable.
Readable. So here, Lordship will kindly come to serial number 6. So all these previous paragraphs are narration of the same thing. Whereas the Central Board of Indirect Taxes and Customs by circular dated 29th May 2020 had extended the last date for electronic payment of taxes due as given in form SVLDRS 3 to 30th day of June 2020. However, the noticee has failed to make payment even within the above extended date. Accordingly, the declaration under the said scheme is treated to have lapsed. So according to them, the scheme has lapsed. Whereas even after the enactment of the Act of 2007, the provisions of the Finance Act pertaining to investigation, enquiry, assessment proceedings, so and so, unaffected by virtue of Section 172(2) of the set. Whereas it appears that since the notice had failed to make payment, noticee had failed to make payment determined by the designated authority. Within the prescribed period, the noticee had acquired liability for payment of the service tax amounting to 6 crores 46 that amount, which is recoverable by following the procedure as prescribed under 73(1) of the Finance Act of 2019. It also appears that the reason for non-payment of service tax by the due dates, the noticee had also rendered themselves liable to pay interest under Section 75 of the Finance Act 1994 and to pay penalty under Section 76 of the Finance Act. So they have converted from the scheme to their normal procedure. That 73, 75, and 76 are applicable. So this show cause they have issued. So in response to that show cause notice of 1st November 2022, the response was given. Page 93. Reply to the show cause notice on 17/7/2023. The causes they have asked why service tax totaling to so-and-so against the so-and-so demanded should not be demanded and recovered under the provisos of Section 73 of the Act under Section 1. So this amount, they said why it should not be recovered. We have already paid it. Much before the show cause notice was, the first cause itself goes. Why interest at the appropriate rate should not be demanded and recovered under Section 75 of the Act for delay in payment of the service tax. 3. Why penalty should not be imposed under Section 76 of the Finance Act of 1994 for failure to pay the service tax by the due dates in violation of Section 68 and 70 of the Finance Act 1994. Why an amount of 6 crores, etc. deposited shall not be appropriated against the above demand. We hereby repudiate all the charges framed against us by the above impugned so-called notice, as these were leveled on utter misconception and without the basis of legal provisions. The impugned so-called notice is clearly barred by laws of limitation without proper investigation and is based on presumptions not permitted by law as well as inferences not permitted by facts, and hence the same should be dropped in the interest of justice. Point by point, we have replied. The so-called notice is barred by limitation. The impugned so-called notice is not maintainable on the ground of limitation. It is to be mentioned that the period of dispute is from October 2014 to June 2017, whereas the instant so-called notice has been issued on 1/11/2022 by invoking extended period of limitation. In this regard, we would like to state that as per Section 73 of the Finance Act, the Central Excise Officer may, within 30 months from the relevant date, serve notice on the person chargeable with the service tax which has not been levied or paid, or which has been short levied or short paid, or the persons to whom such tax refund had erroneously been made, requiring him to show cause as to why he should not pay the amount specified in the notice. The said limitation of 1 year will be extended to 5 years under subsection 1 of Section 73, where service tax has not been paid or has been short paid or short levied or erroneously refunded by reasons of fraud, collusion, willful misstatement, suppression of facts, and contravention of any of the provisions of the rules with the intent to evade or payment of service tax. We have quoted this. Now, Section 70 of the Finance Act, read with Rule 7 of the Service Tax Rules 19 provides that half-yearly filing of service tax return. We have not filed our ST3 returns for calculating the relevant date of 30 months or 5 years as per Section 73(6) shall be required from the last date of filing of ST3 returns. In the instant case, the period of dispute is from April 2016 to June 2017. Hence, the relevant period per date as per Section 73(6) for the disputed period is table below. Next page, we have given the chart. For the period 2014 to 15, October to March, the relevant date is 25th April 2015. 30 months from the relevant date is 11th October 2017. 5 years in where case of fraud and etc. Lordship, that extended period also. 23rd April 2020. And date of issuance in our case is 1st November 2022. In all these areas, lastly, Lordship, 2017-18 part also, April to June, the relevant date will be 30 months period is over on 1st February 2020, and the 5 years period is over on 14th August 2022. Even then also, 1st of November, they have issued. By accepting all their things, application of 73(1), 73(6), 5, etc., if we consider the relevant date as per the dues for the period 2014-15 to 2017-18, the last date was over on 14th August 2022. If Lordship is pleased to look at Section 73. Section 73, may I read it, Lordship? Recovery of service tax not levied or paid or short levied or short paid or erroneously refunded. Where any service tax has not been levied or paid or has been short levied or short paid or erroneously refunded, the Central Excise Officer may, within 30 months from the relevant date, serve notice on the person chargeable with the service tax which has not been levied or paid or which has been short levied or short paid, or the persons to whom such tax refund has erroneously been made, requiring him to show cause why he should not pay the amount specified in the notice. So this part regarding the coherence, then it will be, there will be part of the tax interest as well as the penalty. It will be followed by other two provisions, section 76 and 75 for interest part and for penalty. Their first step itself is erroneous beyond jurisdiction. We are a good citizen. That is why on our own, we have deposited that amount. Suppose, considering their own stand, that the scheme has lapsed and the amount which they have accepted under the scheme, and they have utilized that amount. Now, for our good thing, they are putting us into trouble. That is the problem.
Yes, so Mr. Kyle pays 95 table.
Lordship,
We take this to be correct. 95 table.
Lordship. This is the reply of the petitioner.
On the reply, the table.
Lordship.
If this, this is the factual scenario, suppose.
Lordship.
First part of subsection 1 of section 73 says 30 months. And if the elements, 5 elements, either fraud or collusion, willful misstatement, suppression of fact, or contravention of any provisions are found in with the intent to evade, that intent has to be there, with the intent to evade payment of service tax. Now, prior to issuance of that, that intent is not available because they had deposited. They had deposited the amount. That intent is not available now. Prima facie.
Lordship.
Fraud, collusion, so and so, even that also 5 years.
Probably all these ground will not be come into play in this case. Here, Lordship, in my submission, they under the scheme to avail the scheme, they submitted challan, and that was accepted by the department. There was a limitation up to 30th of June 2020. Thereafter, it was extended, but admittedly, the petitioner failed to make payment within the stipulated time. Lordship, now I please to come to page 89 of the so cause notice. Clause 10. 9.
89.
Page 89. Clause 9. Whereas the noticee paid an amount of rupees 6 crore 46 lakh so and so on 18/8/2020 by challan number so and so, and intimated that they have paid the amount against the SLB DRS 3. Now, Lordship, come to the impugn order, Lordship. How the department, the authority has considered. First, Lordship, page 100. The order is dated 11th of August 2023. And my first submission, Lordship,
This is otherwise an appealable order.
it is appealable under section 86 of the Finance Act.
Here, the jurisdiction part we are excellent. The jurisdiction, they do not have the jurisdiction to issue notice beyond 5 years. That is the series of Supreme Court cases I have brought on that ground.
Lordship, now pay under section 86 of the Finance Act, appeal lies to the CSEC. Now, Lordship, we come to page 108.
Before says that.
Yes. Now, Lordship, we come to page 108. All the points raised by the petitioner before the authority were taken into consideration, and
What did he say about the table?
Lordship, may come to page 108, paragraph 3.1. It has been discussed elaborately, Lordship.
May I place it, Lordship, the impugn order? Because how the contradictions, at one place they are saying it is not covered under 73. And another place they are taking records of 73. Fully confused. The
Lordship,
tax officers are fully confused here. If I am allowed to place this impugn order, Lordship. Lordship will kindly come to 3.2. I have the crux of the allegations in the impugned so cause notice dated 1/11/2022 is that during the period of 1 10/2014 to 36/2017, the said noticee was engaged in providing various taxable services under so and so provisions of Finance Act. And the services provided by the noticee were neither falling under the negative list or covered under the mega exemption notification. The said noticee had opted to Sabka Vikas Legacy Scheme 2019 by filing Form 1 under year-end number so and so, wherein the said noticee had declared a total service tax liability amounting to 6 crores odd rupees. The designated committee, after considering all the relevant materials, determined that the said notice was liable to pay 6 crores 46 lakhs for the period from 1/10/2014 to 36/2017 and issued SBL DRS 3. The said noticee failed to make the payment within the notified date of 30th June. The department had not issued the discharge certificate for Form 4, which reflects the full and final settlement of the tax dues.
Okay, I have read, which is the source of power then?
Source of power.
Noticee is not eligible for the benefits of the
scheme.
Okay, failed,
Then,
but they deposited.
yes, they deposited.
Now,
department
here is a
accepted.
question of now fraud,
No,
misstatement,
no,
evasion.
Lordship, mean-
See, what he is saying now,
no, no,
fallout of,
make out payment within this notice.
failed, okay, failed.
Failed.
Let us assume,
It is admitted.
admitted, failed.
Yes.
Now, 3.3, what he is saying now,
The said noticee has contended that the impugned SCN is barred by limitation, even after invoking extended period of SCN covers from October 2014 to June 2017. The last date for serving notice was 23/4/2020, but the impugned SCN was served in November 2022. I find that the instant SCN has not been issued under the provision of Section 73
let us come to
Finance
so cause notice again.
and as such.
Let us come to the so cause notice.
Lots.
Page 88.
Page 88. Paragraph 10. Page 89.
Hmm.
In view of the above, Assam Cricket Association, care of so and so, is therefore called upon to show cause before the Principal Commissioner GST Central Excise so and so within 30 days from receipt of this notice as to why. 1. The service tax amounting rupees 6 crore 46 lakhs and odd should not be demanded.
No, read to paragraph 8 itself.
Not
Paragraph 8.
8. Whereas it appears that since the notice has failed to make payment of tax determined by the designated authority within the prescribed period, the noticee has acquired liability for payment under of service tax amounting to rupees 6 crore and odd, which is recoverable by following the procedure as prescribed by Section 73(1) of the Finance Act 1994. It also appears that the due date for reasons for non-payment of service tax by the due dates, the noticee has also rendered themselves liable to pay interest under Section 75 of Finance Act 94.
Now, he has tried to relate his source of power to section 73
Yes.
in the show cause notice. Now, why he is saying now that this is a fallout of something?
No, Lordship.
That's I'm asking.
No, Lordship. Lordship, may come to page
Again, once again,
3.3,
page
page 108.
108. 3.3.
The said noticee has contended that the impugned SCN is barred by limitation even after invoking extended period of SCN covers from October 2014 to June 2017. The last date for serving notice was 23/4/2020, but the impugned SCN was served in November 2022. I find that the SCN, instant SCN, has not been issued under the proviso of Section 73(1) of Finance Act 1994.
If once he says in 3.2, suppose that Sabka Biswas is gone,
Yes, gone, Lord.
is gone,
Gone.
then how he can exercise the
No, no.
power under Sabka Biswas again?
No,
If he is not resorting to 73, he is resorting to 73.
it cannot be, Lord.
He is resorting to 73. If once he said that this is gone,
Lordship, in this case, in
then 73. My power is under section 73.
yes, Lordship, that is
Then, why he is saying that it is?
no, Lordship, my submission further, because the petitioner has deposited the tax amount in 2022. whatever is the reason, delay or whatever, they have admitted that the service tax was due. And it was the make payment was made with some delay lordship. So admittedly.
Admittedly, by the time notice was issued,
They deposited
Yes.
the amount.
where any service tax has not been paid, that is gone.
No, lordship. No, lordship, whatever lordship want to say, I understand lordship, but in my humble submission, since they paid the amount in 2022 with delay, they admitted that due to COVID or some other reasons, the amount could not be paid within 30th of June. And the scheme was lapsed by that time.
So see, let us assume scheme is lapsed.
Yes, Lord.
Everything is out of consideration. What about this table then?
No, that is lordship, a prima facie.
The table, if table is correct, suppose, subject to your instruction,
Lordship.
if this table is correct, and this has to be page 95. If this is correct, and this has to be read coupled with the proviso to subsection 1, intend to evade payment, that is not there because of their voluntary disclosure,
5 grounds.
that is gone.
Yes, lordship. Only-
Fraud, I don't think.
No, it will not.
Collision, willful misstatement, your designated committee has accepted it.
Yes, lordship. That is,
Suppression of fact,
I think,
then 5 years is even 5 years.
yes, lordship.
Even we assume that he has the jurisdiction. That ground is to be there.
No, lordship, may, if you lordship allow, I want to further read.
Yes, sure.
I find that the instant SCN has not been issued under proviso to section 73(1) of the Finance Act.
Where is saying that?
Paragraph 3.3, middle part. I'm again reading lordship from top.
That I have read.
Then lordship.
I have not understood what his line of reasoning.
And as such, the limit, lordship, as such, the limitation for serving SCN is 30 months from the date relevant date. Since the instant SCN is the fallout of the Sabka Vishwas legacy scheme, the relevant date is 36/2020, which was the due date for making payment under SLB 3. As such, the last date for serving SCN for the SLBR is 31/12/2022. The instant SCN was issued on 1/11/2022.
Why he is saying, Mr. Kyle? Because in paragraph 3.2, he says this Sabka Vishwas scheme gone.
Lordship, here
It is gone.
they make payment as disclosed in SLB 1, lordship. And
That is there.
lordship, then next paragraph 3.4. The plea taken by the said noticee that they were unable to make payment due to the COVID pandemic is not acceptable. After the generation of SLB 3 on 29/2/2020, the said noticee had ample opportunity to make the payment within 4 months till 30th June 2020. The first lockdown was declared by the government of Assam with effect from 18 hours of 24/2020 to 24 hours on 31/3/2020, while notification dated 23/3/2020. I find that the said noticee has generated challan mandate on 12/3/2020, which was before announcement of the lockdown in the state of Assam. They could have deposited the tax into government exchequer. Moreover, banks were excluded from the restrictions imposed by the above direction of the government, but they failed to make payment for the reasons best known to them. The said noticee submitted that they were statutorily restrained, debarred from making any payment during the COVID lockdown is not correct. The
No,
initial,
admitted. These are admitted facts.
yes,
They failed. Whether COVID or not, they failed. But they deposited the amount.
yes,
Now-
lordship.
Now 73, by the subsection 1, by the substantive part, it is 30 months. And by the proviso, it is 5 years.
Lordship, even the notice is not required to be issued in such type of cases. In case of Dharampal Satyapal, so today I have not brought the judgment. Even the amount is admitted by the SEC and is accepted by the revenue. Then lordship, the department is not required to issue notice. If the law provides for payment of tax, penalty or interest, then they are required to pay lot.
That is another issue. But here you are issuing so-called notice.
No, even then lordship,
Issuing so-called notice, exercising some purported power and jurisdiction. Whether that jurisdiction is available or not under section 73. That is one of the issue.
no lordship, even then, if it is so,
No, question is, even then is different thing.
lordship.
Public order publicly made.
Yes, lordship, there is no dispute to that.
Is to be examined on the basis of the region cited. We are examining that issue.
No, lordship, examine, we have no difficulty in that. And lordship.
That is difficult. 73, 3.3 paragraph. Paragraph 3.3 is reasoning is somewhat.
No, I got lordship's point, lordship. Lordship, examine, there is no.
This
difficulty.
table is also different.
No.
If table is not disputed, suppose.
No, it is admitted that the they were liable to pay tax. And with some.
Yes, yes.
Some delay, it was deposited. Now, lordship, whether they are entitled to pay.
See,
interest on-
otherwise, see a scenario, they fail 2014 to 2017.
Then lordship, there is barred by limit.
That you had the jurisdiction till 30th of March, 30 months.
30 months, then.
Then after, if those elements are available, any of the 5
Then it may be extended to. 5.
grounds are available, it can be up to
5 years.
5 years.
Sure.
You did not. You did not. Because I see that 5 years period was available even after introduction of GST.
Yes, lordship, that is confirmed by our High Court also.
Or 73 is always available. Finance Act 1994 is always available. That you did not invoke at that time. Then you launched a scheme. They came forward, deposited the amount.
Yes, lord.
Right? Deposited the amount, then whatever is there, is there anything in the Sabka Bika scheme that he failed?
If he fail, then lordship, normal procedure will.
Normal. One has to revert back to the normal thing.
Yes, lord.
Then normal thing, if the normal thing is there, then 73 comes into the fore.
No, lordship, here another fact is that the
Ah.
tax was deposited by them.
Yes.
Hmm.
So intent to evade gone.
No, lordship, I understand, lordship. If normal thing is could have been there, lordship, section.
It is there, 109. FAQ.
Lordship, section 109,
109, page 109.
page 109. Yes, what happened? Lordship, may come to.
FAQ 52.
Hmm.
FAQ 52.
There the initial deadline for making payment.
No, in between italics.
Yes, lordship. There
What happens?
I do not make payment of
If,
the
I
amount.
think it is if.
The declaration shall be treated as lapse and benefit of the scheme will not longer be available.
No longer available, then it comes to the normal field. And normal field comes, 73
No,
comes.
Another fact is rightly wrongly they deposited the tax.
That is why, that is gone.
We have wrongly deposited. You
Yes.
should not have deposited.
Yes, lordship.
We will have
To
the
away,
benefit of 6 crores.
that foundation is gone.
If they could have not deposited that, then question would have been different, lordship.
Now, he is not saying anything about fraud, misstatement,
lordship.
pollution.
Probably that
Intent
can,
to evade is not there. Even by 30 months and 5 years, that is not also there. FAQ makes it clear.
lordship may come to the 3.6 also. Lordship, if they could have not deposited, then matter would have been different, entirely different, lordship.
Because no, I have understood your legal submission. It will be based on subsection 3 of section 73. But it is relatable to subsection 1.
Which one, lordship? Section?
Subsection 3 of section 73. When interest, because everything is on interest.
Interest and penalty now.
Penalty is one part.
No,
First, interest.
interest.
So interest part is relatable to the original
71,
71, subsection 1.
subsection 1.
Subsection 3 is relatable to subsection 1. And your case is subsection 3. You have been imposed penalty under subsection 3.
Yes.
And plus, sorry, interest,
Interest.
plus penalty.
75.
Huh?
Interest levied on 75.
No. Come to paragraph 3.8.
3 point.
3.8, page 10,
Yes, Lord.
110.
The said notice contained that the
See.
demand of interest and penalty is totally wrong, as there was no tax liability outstanding at the time of issuance of SCN was issued on 1/11/2022, whereas they had deposited the tax on 18/8/2020. In the said regard, I would like to refer the provision of section 73(3) of the Finance Act, which read as under, where any service tax has not been levied or paid or has been short levied or short paid or erroneously refunded.
Mr. Scar will examine the issue.
Last line they have said, I hold that the instant case is not covered by the provisions of section 73(3) of the Finance Act.
Then
Page
where is the
110.
source then?
Where is the source?
Then it is
Actually, we'll
illegal.
file another writ petition now to recover our whatever we have deposited. We'll recover. that.
Yes,
Will examine.
let them close it.
I had Mr. D. Hoike, Senior Counsel, assisted by Mr. B. Gogoi, Counsel for the petitioner. Any central government counsel, or you can accept
Not, but finance.
Mr. S.C. Cal, Standing Counsel, Central Goods and Services Tax for all the respondents. Full stop. The petitioner, a society under the Societies Registration Act, has projected that during the period from during the period from
2000, October 2014 to June 2017.
October 2014 to June 2017, comma, it did not deposit the service tax. Full stop. When the central government, when by the, what is this Finance Act?
Finance Act 1994.
When by the Finance Act 2019, comma, a scheme named Sabka Vishwas, within bracket, Legacy Dispute Resolution, bracket close, scheme 2019 was launched. WEF, from, with effect from?
For a limited period, Lord.
Was launched, comma, it sought to avail the benefit under the said scheme by voluntarily declaring its liability for extending taxable service to the extent of 6,46,39,056 by submitting form SBLDRS1 on
In the month of February,
page 70.
no, on 30th of December. No. We submitted it in the month of December 2019.
That is 30/12/2019.
Yes, 30/12/2019.
On 30/12/2019, full stop. The voluntary disclosure made by the petitioner was examined by the designated committee, and after reaching satisfaction, comma, the designated committee issued form number SPLDRS 2 or 3? 3. Allowing the petitioner to deposit the amount of rupees 6 crore 46 lakh 39,056, as declared by the petitioners in SB form number SBL DRS 1.
On
Full stop.
29 to 2020.
29 to 2020. Full stop. Thereafter, the petitioner generated the challan to deposit the said amount having last date, having expiry date
Expected 30th.
of 30/3/2020. Full stop. It is a case of the petitioner that due to declaration of national lockdown
Yes.
in the entire nation on and from 24/3/2020, it could not deposit the amount disclosed by it voluntarily on or before 30/3/2020. Full stop. Thereafter, though the period of depositing the amount was extended to 30/6/2020, there was lockdown prior to 30/6/2020 in the state of in the area where the office of the petitioner is located, with effect from 1/6/2020.
No, will affect from 23rd.
Okay, with effect from 23/6/2020. Full stop. And as a result, it could not deposit the said amount on or before 30/6/2020. Full stop. When after 30/6/2020, the window of depositing the amount under the scheme was not possible, the petitioner represented before the respondent authorities, while its representation dated 15/3/2021, to allow the petitioner to deposit the amount as declared in SBL DRS 1 and SBL DRS 3. Full stop. When no response was received from the respondent authorities, the petitioner deposited the amount on 18/8/2022 by regular procedure. Full stop. After depositing the same, the petitioner again represented before the respondent number, principal commissioner, respondent number.
We inform principal commissioners.
Page 88,
CDS,
respondent
page
number.
84.
Respondent number 4. To issue SBL DRS 4. Full stop. But instead of issuing SBL DRS 4 to the petitioner, the petitioner was served with a demand show cause notice dated 1/11/2022, purportedly invoking the powers under section 73(1) of the Finance Act 1994, asking the petitioner to show cause as to why it will give 89. Is 89 or 89 or as to why? A 1, 2, 3. Pencil to pencil. The show cause notice had mentioned about deposit of the amount of rupees 6,46,39,506 from the petition on 18/8/2022. Full stop. The petitioner submitted its reply to the said show cause notice, raising a specific plea that under the provisions, even under the provisions of subsection 1 read with the proviso to subsection 1 of section 73 of the Finance Act 1994, neither the period of 30 months from the relevant date nor the period of extended period of 5 years from the relevant date under the proviso to subsection 1 of section 73 was available to the respondent authorities to invoke the power under section 73 of the Finance Act 1994. Full stop. A number of other contentions were also raised in the reply to SOCO's notice. Full stop. Para. When the petitioner, full stop. Who has passed the order? Respond number? After submission of the reply and affording personal hearing, the impugned order in original dated 11/8/2023 came to be passed, has been served upon the petitioner, asking respond number 3, asking the petitioner to confirming demand of service tax. But he has appropriated that amount.
Yes.
They have appropriated.
Okay. So basically it is penalty
And
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 interest.
interest. Okay. Post of the relevant excerpts of the order in original dated so and so is as after. Is 112. Also challenging the imposition of penalty and interest and penalty. The petitioner has approached this court by the instant writ petition. Full stop. Is a Soikia. And senior counsel appearing for the petition has submitted by referring to the table.
Page 95.
Table, which is part of its petitioner's reply to the SOCO's notice, has submitted, has reiterated his submission that in any view of the matter, the SOCO's demand cum SOCO's notice is barred by limitation. Full stop. He has further submitted that even assuming that Sabka Vikas so and so scheme had expired, if the so and so scheme had expired, then the adjudicating authority had no power and jurisdiction to resort to any of the provisions of the said scheme. Full stop. He has further contended that the adjudicating authority had no authority and jurisdiction in such scenario to invoke the provisions of section 70 of the Finance Act.
One more submission that they cannot appropriate that amount also. That is also my submission.
Okay. It is in such scenario, the appropriation of the amount of
Already-
rupees 6,46,39,056. Is it your case, pleaded case?
We are having no there
It
will
is not your pleaded case.
when I gone through it, I said that prepare another writ petition.
It is not your pleaded case.
My submission I can make always.
Okay. A prayer is there.
That is why I will another writ petition will come. But my prayer is that they have appropriated that. That is also not
not permissible under the law.
under the law.
Full stop. Mr. Kyle, Planet Standing Counsel, CGST has submitted that the order in original is appealable under section
86 of the Finance Act.
86 of the Finance Act 1994, and as such, the instant writ petition is not to be entertained. Full stop. He has submitted that the petitioner has not been able to make out any case for interference. Full stop. In reply, Mr. Soikia Alliance Senior Counsel for the petitioner has submitted that a writ petition is maintainable if the adjudicating authority has no authority and jurisdiction to issue demand comes to cause notice. Full stop. The matter would require further examination. Full stop. Issue notice returnable in
0104, 1st April.
Huh?
1st April.
1st April. 0104, so and so. Having regard to the respective contentions advanced by the counsel for the parties, this court is of the considered view that the petitioner, in the context of the provisions of section 73 of the Finance Act 1994, more particularly in view of the period within which, in view of the period mentioned, normal period as well as the extended period, has been able to make out a privacy case for interim relief. Accordingly, it is observed that till the returnable date, the impugned order in original dated
11th August 2023,
11 August 2023
and they have issued another reminder that was
shall be kept in abeyance.
not fixed. Yes. Deeply.
Item number 8 for admission.
My lord, may you be pleased to fix the matter at 2 p.m. It's mine.
You're for whom?
I'm for a respondent. I'm on behalf of Jyotimoy Roy.
To kind of
Much.
Item 9.
Lordship, counsel KP Pathak will appear in this matter. He's on legs. Matter may be kindly taken up after some time.
after some time. Let us see.
Item number 10. Item 10.
There is no representation on behalf of the petitioner today on call. There is no representation on behalf of the respondent sides also. In view of the same, let the case, for instance justice, be listed after 2 weeks. On a date to be fixed by the office.
Item number 11 for orders. Item 11.
May I page your lordship? Matter may be possible for time being, lordship.
For hearing item number 12.
Motion, 16. How color does it sign?
Item number 16. The subject matter of the petition, the petitioner, he was an upper division assistant at the 11th.
Standing counsel, High Court.
Yes, Lordship.
Where is he? You are?
No.
Where is the standing counsel? Nobody is available on the other side.
It has been adjourned many times. Today it is reached now, my lord. Many occasions it is matter because of the penance of the case, the petitioner received very small amount of pension, my lord. Because he 3 increments was withheld as punishment and he has retired. And because of that, he received a small amount of punishment. He suffers from.
The other side should also be there, at least. Who are the respondents? I think it is reflected. DHG, standing counsel. Yes,
I beg apology, Lordship. He is on election court number 20, Lordship. Taken up after some time, Lordship.
taken up, we have hardly one method.
Oh, Lordship,
Then
maybe
it
it
is
is
gone.
part third also, Lordship.
Huh?
Part third also, Lordship. We'll
Huh?
submit our
What record is
the
part
next
third?
Lordship. Let him submit, Lordship. We'll file our reply on the next day, Lordship.
No. This is installment, no. Okay, next. Wait 1 minute.
Item number 17.
Yes, 17. This is also High Court.
17, Lordship, we have not received the copy also, Lordship.
Not received the copy.
Nobody is appeared perhaps, Lordship. And
It was
nothing
there.
has been filed on behalf of GHC also, Lordship. Perhaps. Subject to correction, Lordship.
No counter affidavit also.
Lordship. After perhaps Lordship order, Lordship reflect that name of the CGHC, Lordship. In the last occasion.
Huh?
Lordship.
No. Rule issued. The respondent shall file their affidavit, 2019 order. Failing which the court shall consider to pass consequential order against the erring respondents.
Perhaps, Lordship, no copy has been served also, Lordship. May kindly.
As there is no one representing the GSC, leaves the matter so and so. GSC to reflect.
Yes, Lordship.
SC, GSC.
After that, Lordship, name of the GHC has been shown, Lordship. We have not get the copy also, Lordship, till date in this matter. I have asked other council to also, Lordship. They have also said the same, Lordship. They have also not get the copy, Lordship. And since the petitioner is also absent, perhaps.
Ready? এইটোৰো নাই কিয়া পিটিশনৰ নাই এবাৰ ৰ'ব এইটো পিটিশনৰ নাই এইটো কি কৰা যায় এতিয়া মইতো নাথাকে What is the case about? Do you have any idea?
No. He filed to protect.
Okay, Mr. Das will be available.
Lordship, after some time, Lordship.
Okay.
One
Okay, Mr. Sharma will take up your matter then. We'll just rise for 2-3 minutes. We'll take up your matter.
Otherwise,
Inform him, we'll be taking up his matter.
third matter is going on, Lordship. May take up some time, Lordship. Otherwise, Lordship may take up at 2 also, Lordship.
We are running out of time. Anyway, we'll take up this.
Lordship.
The petitioner, he was upper division assistant in the establishment of the CGM Bojali at the relevant times, my lord. That is, and his original house is in the remote area, my lord. So they have a joint family and the electricity.
Bit louder, Mr. Sharma.
Sorry. He has a joint family, so someone without his knowledge took the electricity connections without permission, my lord. That is why the proceeding was drawn up, or the case was filed by the electricity under section 39 of the Electricity Act, my lord. So in that case, the additional session judge, Borpata, has convicted him and awarded 5 years fine of rupees 5,000 in default to undergo SI for another undergo as 2 months, my lord. So against that, he has preferred an appeal before the Honorable High Court, my lord. The Honorable High Court has modified the sentence that instead of sentence, he was allowed to go on probation, my lord. So when the sentence is modified, so punishment does not remain, he was allowed to go on probation. So in spite of that, the departmental proceeding was drawn up by the disciplinary authority, that is the CGM's Barbata, my lord. Your lordship kind of see the charge against him in that case. Charge by the 31 to 33 piece. Charge your my lord. The statement of allegation and page 32, my lord, charges.
Sir,
That-
yes, in the office for the so are found to have been convicted in sessions case numbers when sentenced to pay a fine of rupees. Interest and has also deposited the fine amount which amounts to violation of service discipline. You are hereby directed to show coach. The rule 9 of the Assam Services liquid. The Constitution of India supply any of the penalties that specified into anything that should not be imposed on you of the following charge based on statement of allegation. You have been convicted and sentenced to pay a fine of rupees 5,000 in Sessions case 4 of 2000 under 135 Electricity Act on something. You have deposited the fine amount, which shows that you have committed moral turpitude and gross violation of discipline. You are required to submit your returns. Okay, this charge sheet was submitted to you. Then what happened?
Yes, thereafter, along with the charge sheet, the documents were included, the certified.
Certified copy of the judgment.
So, and witnesses, 2 witnesses are mentioned, my lord. An inquiry officer was appointed, additional CGM. Inquiry officer has submitted report, very cryptic report, my lord, page
Fine
43,
receipt.
43, my
He
lord.
deposited the fine amount.
Yes, he deposited a fine amount, and thereafter he has preferred appeal before the Honorable High Court. The Honorable High Court judgment.
Your reply, let us see your reply first.
Reply against the charges, my lord.
Hmm.
I have the reply. Suppose reply page 34 to 35, my lord.
Is without prejudice.
34, page 34, my
Subject to the
lord.
outcome of the appeal. Prepared. "21 days. The third, in which case has been listed. Several location did not reach. Allow. Condoning early. Raise the criminal appeal for admission hearing at the earliest. Accordingly, did not reach this party convention, but a state appeal can be listed. There are strong grounds of appeal and such is open. Order. Okay, what happened in the appeal? Criminal appeal.
Yes.
We have appeal dated lordship,
Appeal is directed against the order passed by the
case number 37 lordship.
37.
Under 11 portion lordship.
special judge session by the impugned judgment. Convicting
Page 36.
the accused persons, they have been sentenced to pay a fine. D.K. Sharma did not seriously challenge the finding. Trial court. This is his first conviction. Release on probation.
Sentence.
So you were released on probation under section 4.
Yes, then conviction does not say, if the order is there, the conviction remains, but he was allowed to go on probation. Then the conviction is about, it is modified, my lord.
Where from you are saying? Which law? More tablet pronounce. Which law?
No, the word.
Which
meaning-
law?
The meaning of the word modification, my lord.
Modification is from fine to probation. Or what?
Yes.
Sentence to?
Sentence
Sentence to?
sentence is modified, my lord, thereafter sentence does not
Sen-
mean he is
One
allowed to go on
minute.
probation.
Okay. It is your submission. What is
Yes.
the law?
Otherwise, lordship, there is a judgment lordship.
What is the law? Submission is one. And what is the law?
But that's the literal meaning of the word modification, my lord. Modified, my alteration, my lord. Alteration means instead of punishment, he was allowed to go on probation, my lord.
So what is the law?
So that is the
Then what happened? After criminal appeal, you are preparing this writ petition.
yes.
For what?
No. Criminal criminal appeal is disposed by the additional session judge, my lord. It is. I'll find
No,
out.
criminal appeal was disposed by this court.
Appeal is
Appeal,
disposed. Yes.
sentence
Yes.
is modified. In other words, the appellant is allowed to go on
Go on probation. my lord.
executing a bond
Mm.
under
Section 4 of the Probation of Offenders Act.
So
So when he is allowed to go on probation,
mm,
the conviction does not remain, my lord.
so
It is modified.
so is it a law?
You will also kindly see the inquiry report, my lord.
No, then what happened in the disciplinary proceeding?
My lord.
What happened in the
That
disciplinary
is
proceeding?
the disciplinary proceeding, the inquiry officer has
Let
submitted
us see.
report.
Disciplinary proceeding, let us see.
Page 43,
43, let us see.
43 of
Let
the
us see.
inquiry officer report, my lord. It
Let
is a
us
very
see.
cryptic report without discussing any evidence.
Let us see.
My lord.
You must have read it many times. I have not read it for a single occasion. Let us read page 43.
I'll read out.
Have we gone through the So come to page 48.
This is the order.
So three increments without cumulative effect. Yes, what is the law? If suppose it has been modified
More.
under section. Huh? Itu typical to get typical already. Yeah, zero. What did that one? Itu itu apa aja? Tapi sebenarnya untuk kita perlu yang lain itu saya perlu mau coba bikin teman kan. Yes, any law? Provision of offenders act must now.
Apart from that, I may be allowed to submit on the inquiry report. Inquiry officer does not follow the procedure prescribed under law, my lord, in conducting inquiry, my lord.
What, it is an admitted fact.
No, still,
Mr. Sharma, Constitution.
the-
Constitution of India, latest Constitution. It is not only disciplinary proceeding. First, please satisfy me whether this is conviction has been obliterated.
no, it is not the conviction because conviction is modified.
That is what I am asking.
Not-
From sentence of what has been changed? One is conviction and sentence.
Yes.
Conviction is under section 135 of the Electricity Act
Act.
and sentence is 5,000, right?
Yes.
What has been modified?
That
Which part is modified?
5,000 is modified, my lord.
5,000 modified.
Modified.
So what remains already? Conviction.
No, he has there on condition that.
Show me the law.
No,
Conviction and sentence. First one is convicted
Convicted.
of murder.
Yes.
Then he is sentenced to undergo life imprisonment,
Yes,
right? Or one is convicted of theft
yes,
and he is sentenced to undergo 10 years of imprisonment,
Yes.
suppose. Now, in appeal, the court has modified
yes,
that instead of going to jail,
Yeah.
I am releasing you on probation,
but modifying the sentence, my lord.
modifying the sentence. Where is the conviction?
There are two aspects, my lord. If the appellate court has said that the conviction remains, but he is allowed. to-
Where is the conviction set aside? Tell me.
The set aside is different.
See your appellate judgment of this
But
court.
instead of this or this, my
See,
lord,
please come to the
instead of
appellate judgment,
37.
Page 37, Lord.
page 37. However, sentence is modified.
Yes.
Appeal is dismissed. Dismissal of appeal means conviction remains.
But modifying the sentence.
Sentence.
Yes.
So conviction remains.
Sentence is modified instead of
Yes,
sentence.
nothing more is
No,
required.
Instead of sentence. Moreover, I may be allowed to submit on the inquiry report, but it is a Supreme Court case. There is a Supreme Court case, the Order 9 Rule 7 is not followed.
Supreme Court is not above constitution perhaps.
Moreover, the
Article 311.
witness must be examined in Department of Inquiry.
Article 311.
No, it is.
Constitution.
It
This
is,
court is not above the constitution.
no, it is governed by Assam Service Discipline and Appeal Rule that the.
This service rules is above constitution, not constitution.
No, it is the procedure provided in the.
Mr. Sharma, I am asking you a simple query. Is this Assam Services Discipline and Appeal Rules 1964 is above the
No, no.
Constitution of India?
Constitution is the highest law of the
Now
land.
then,
It is not
come
above
to-
Constitution.
Come to,
But under
come to article.
under Constitution, so many laws are framed. And the procedure.
Okay, you go on submitting. When I make some query, you continue your submission. Go on.
But the Supreme Court has stated the witness must be examined in the Department of Proceeding. If the delinquent employee does not appear, still witness is to be examined. Without that, it is invalid, my lord. But here witness is not examined, my lord. It is 2010 Supreme Court. It is held that the departmental inquiry officer status and duties. Hell, inquiry officer acting as a quasi-judicial authority is in the position of the independent adjudicator. He is not supposed to be,
How much time will take Mr. Sharma to make your submission?
my lord.
Ignoring Article 311, subclause 2, how much time you will take?
No, I am not disputing that, my lord.
How much it will take?
The Supreme Court says that the procedure, the inquiry must be held according to procedure, my lord. The witness
When
must-
there is a
because
conviction,
this
when
is-
there is a, Mr. Sharma, I'm asking you a query. When there is a conviction and that conviction stands,
Then, my lord,
whether such kind of inquiry is a sine qua non?
if your lordship hold that the conviction is there, then
No, I am not saying already the appellate court is saying appeal is dismissed.
no, my interpretation
Page
is
37.
it is modified. When it is modified, the conviction does not
Sentence.
sustain. my
No,
lord.
at least I am that much conversant with English language that upon hearing the learned counsel for both the sides, the appeal stands dismissed. Appeal is against conviction and sentence. So appeal is dismissed. However, sentence is modified.
Yes.
Conviction remains.
Modification means alteration. He is allowed to go on the probation. Allowed to go on probation. Then he does not does not suffer the punishment, my lord.
Okay, give your Supreme Court decision.
No, B, my lord. Because the departmental inquiry officer status, head inquiry officer acting in constitutional authorities.
Yeah.
Constitutional authority in the position of an independent adjudicator. He is
Sarosh
not
Kumar Sinha.
supposed to be representative of the department.
Which
of-
paragraph you are reading?
Madam?
Which paragraph you are reading?
Second pair, my lord, B.
Second para.
Had not B, my lord.
Head note B.
B, first pair, yeah.
Google. What is your prayer here?
My prayer is to set aside the punishment awarded by the disciplinary authority. Because the under the faction circumstance of case also the punishment is too severe, my lord, in government. Because his pensionary benefit comes to a very small amount. And
No, mister, that submission does not remain because page 50, it says to stop 3 increments without cumulative effect. There is no adverse effect on the pensionary amount, Mr. Sharma, don't make such submission.
No, no.
There is no effect on pensionary amount. It was only increment, 3 years, without cumulative effect.
No, increment because of stoppage of increment.
No,
he-
please read.
No, one interpretation.
Please read. What is page 50? Please read.
That is here, they would have committed, but.
What is the
What
what is the interpretation of stoppage of 3 increments without cumulative effect? Are some services and
No, when the increment was.
what is the effect?
No, what.
Will there be any effect on the pensionary amount?
Yes, my lord.
How?
Yes.
Please explain.
AG has given that because of that, your amount reduced to minimum because at the time of his retirement, his amount come to a very small one. On the basis of that, the
The manual of departmental proceeding.
pension was calculated by the AG, my lord.
Manual of departmental proceeding.
When increment is not done, the salary is also reducing, and on the basis of last salary, the pension was calculated by the AG. So it has affected him, my lord.
Good. That submission does not hold any water because of this explanation given in the book. Illustration has been given. Suppose the employee at the time of inflicting the punishment was on a pay scale 580. 580. Now, if he is given punishment of stoppage of 2 increment for 2 years without cumulative effect. Now 580, next increment will be 600. Next increment will be 620. Second increment. Third increment is 640. Right? If he is given the penalty of stoppage of 2 increment without cumulative effect, then in the third year, he will get 640. But if it is with cumulative effect, in the third year, he'll get 600. That is the law. Yes, Mr. Salda.
AG has given a very small amount of increment, my lord, okay, pension, my lord.
We are onto this.
Lordship,
We don't know about AG.
Perhaps, Lordship, his submission is correct, Lordship, because Lordship may kindly see the affidavit in opposition in page number 5, Lordship. He has already another disciplinary imposing penalty order was there, Lordship. It is not under challenge, Lordship.
Which one?
Page number 5, Lordship.
Page number 5 of what?
Our affidavit in opposition, Lordship. He has accepted the punishment, Lordship.
Please,
1 minute. I have not seen you.
Affidavit filed by the respondent number 2 and 4.
We should even think.
Which paragraph?
Paragraph number 6, Lordship.
Your penalty, small amount is because of this penalty. That penalty was penalty of withholding 3 increments with cumulative effect. You had suffered earlier also. It will lose out.
In this case, my lord, considering the facts and circumstances, at least one increment may be withheld, my lord.
Para 10 and 11. Provisional offenders act আছে? Section 4 of Provisional Offenders Act. Section 4 also does not say that your conviction is removed. This one yours.
Lordship.
If you also think that conviction sustained that way, considering the facts and circumstances, one increment may be withheld, my lord. It will be the end of justice in this.
That is the law also that unless it is shockingly disproportionate. That is not shockingly disproportionate because stoppage of 3 increments without cumulative effect.
One may be within.
Because the disciplinary authority had the power to dismiss you also in the case because of your conviction and because of the constitutional provision. They had considered your case leniently.
It depends upon the facts and circumstances of the case, my lord. Here the.
We'll consider.
The facts and circumstances.
We'll consider. Please take your seat. The writ petitioner invoking the extraordinary and discretionary jurisdiction under Article 226 of the Constitution of India, has preferred the instant writ petition seeking issuance of a writ in the nature of certiorari to set aside and quash an order dated 16-3 order under memo number PSP, dated 16-3-2017, passed by the learned Chief Judicial Magistrate, Borpeta, as the disciplinary authority in disciplinary proceedings, D full stop P full stop number 1/2013. We check the facts. I'm dictating. Don't keep sitting without looking at the documents. By the impugn order dated 16/3/2017, the disciplinary authority, the as the appointing and disciplinary authority. By the impugn order dated 16/3/2017, the appointing and disciplinary authority had imposed a penalty of stoppage of 3 increments without cumulative effect. Under Rule 7 within bracket 2 of the Assam Services within bracket Discipline and Appeal Rules 1964, upon the petitioner as the delinquent. Full stop. Where the sequence of events which have led the petitioner to prefer the present writ petition can be delineated, exposited as follows. Para. The petitioner was initially appointed as a lower division assistant in the office, in the establishment of the learned Chief Judicial Magistrate, Borpeta, within bracket the respondent number 3, on 1/2/1982. Full stop. Thereafter, the petitioner was transferred to the establishment of the learned Subdivisional Judicial Magistrate, Bozali, Pachala on 1/3/1996. Full stop. At the time of preferring the writ petition, the petitioner was serving as the upper division assistant in the establishment of the learned and at the time of preparing the writ petition, the petition was serving in the said establishment. On 10/5/2002, a first information report came to be lodged by the then Assistant Executive Engineer, Assam State Electricity Board, ASAB, Borpeta Road Division, before the officer in charge, Borpeta Police Station, alleging inter alia that the accused persons illegally connected electricity in their respective houses situated at Borbila and Bati Kuriha villages. Full stop. The affair mentioned that such illegal connection of electricity were done with overhead wire through hooking from their respective houses, and finding such illegal connections, electricity connections, the ACB got them disconnected due to non-payment of charges. Full stop. On the basis of the said affair, the crime case, Borpeta Police Station case number 177/2002, was registered for commission of offences under section 379 Indian Penal Code, read with Section 39 of the Electricity Act, comma, Electricity Act. The petitioner was arrested in connection with the said case, as the case was registered against the petitioner and two other persons was arrested during the course of investigation of the said case, as the petitioner and two others were implicated as accused persons therein. Full stop. After completion of investigation, comma, the police submitted charge sheet against the accused persons against four accused persons, including the petitioner herein. Full stop. Initially, comma, all the four accused persons appeared before the trial court, not a trial court. But subsequently, comma, one of the accused persons, comma, Pramod Chandra Das, failed to appear. To face the trial, and the learned trial court, after declaring him as an absconder, comma, proceeded with a trial against the other three accused persons. Full stop. The learned trial court of additional session judge within bracket FTC, comma, Borpeta, finding privacy materials against the accused persons, comma, framed the charge under section 135 within bracket 1 within bracket small a of the Electricity Act. Full stop. When the accused persons pleaded not guilty, comma, the trial proceeded, and in the course of the trial, comma, the prosecution examined four witnesses, including the investigating officer. Full stop. The defense case was one of total denial, but the accused persons did not enter into defense by adducing evidence. Full stop. The learned trial court after appreciation of evidence, comma, reached a finding that the accused persons, that's Upendranath Deka, within bracket, the petitioner, and Ojit Das, had committed the crime by connecting their houses with illegal electric connection by hooking from the main electric line of the concerned area without any authority. Full stop. The learned trial court found the accused persons, including the petitioner, guilty of the offense under section 135 1 small a of the Electricity Act and had accordingly convicted both of them. Full stop. The learned trial court was of the view that because of the seriousness of the offense, the accused persons could not be dealt with either under section 360, Code of Criminal Procedure 1973, or under section 4 of the Prohibition of Offenders Act 1958. Full stop. After hearing the accused persons on the point of sentence under section 235(2), CRPC, the learned trial court, by its judgment and order, dated
15/9/2012.
15/9/2012,
15/9/2012.
convicted both the accused persons under section 135(1)(a), Electricity Act, and sentenced them to pay a fine of rupees 5,000 each, in default to pay the fine, to undergo simple imprisonment for another period of 2 months. For a period of 2 months. Full stop. One of the accused persons, PIJ, Gobindo Talukdar, was acquitted on benefit of doubt and he was set at liberty forthwith. Full stop. Para. On being so convicted and sentenced, the petitioner deposited the fine amount of rupees 5,000 before the learned trial court. Past in judgment, in Sessions case number 4/2011. The petitioner deposited the fine amount of rupees 5,000 before the learned trial court of additional Sessions Judge Borpeta, FTC Borpeta, on 12/10/2012. Full stop. Aftermath of his conviction and sentence in Sessions case number 4/2011, the petitioner was served
Page 30, Lordship.
30.
Lordship.
With a show cause notice dated 15/10/2012 by the respondent number 3 as the disciplinary authority stating that it had come to the notice of the disciplinary authority that the petitioner noticee was found involved in a criminal offense under section 135 1A of the Electricity Act, under which he had been found guilty and convicted by the Trial Court of Additional Session Judge FTC Borpeta on 15/9/2012 in Sessions case number 4/2011. With imposition of a fine amount of rupees 5,000. By the so-called notice, the disciplinary authority had conveyed that being a government servant, whose conditions of service were governed by the provisions of the Assam Services within bracket Discipline and Appeal Rules 1964. Within bracket the 1964 rules or the rules 1964. Comma. Why the petitioner noticee was asked to show cause as to why disciplinary action against him should not be taken under Rule 6, RW Rule 7, RW Rule 10 within bracket 1 of the 1964 rules, as the offense committed by the petitioner noticee was found to be an offense involving moral turpitude. The petitioner was asked to submit his reply to the said so-called notice within a period of 15 days from 15/10/2012. When he was saying that he has prepared an appeal, somewhere he said, right? Where?
$37.
37.
Page.
No, this is the order of the High Court Lordship.
It is High Court.
Page 36.
Somewhere he said that I have prepared an appeal. So you wait. You wait.
Page 34. Page 34. Replace.
Is 34. Okay, 1st July. Okay. Okay. The so-called notice was followed by a sursit dated 20/06/2013. By the sursit, the petitioner was directed to show cause under Rule 9 of the 64 rules, read with Article 311 of the Constitution of India, as to why any of the penalties as specified in Rule 7 of the 64 rules should not be imposed upon the petitioner based on the statement of allegation annexed therewith. Full stop. As per the statement of allegation, which accompanied the charge sheet, comma, the petitioner, while serving as the upper division assistant in the establishment of the subdivisional judicial magistrate, within bracket M, Bojali Pachala, was found to have been convicted in Sessions case number 4/2011 and was sentenced to pay a fine of rupees 5,000 under section 135(1)(a) of the Electricity Act, and the petitioner was found to have deposited the fine amount, which amounted to moral turpitude, misconduct, and violation of the service disciplines. Full stop. In the list of documents, the charge sheet was accompanied with a list of documents and a list of witnesses. Full stop. The list of documents consisted of a certified copy of the judgment and order dated 15/9/2012, the petition submitted by the petitioner on 12/10/2012, for submission of the fine amount, for deposit of the fine amount, and a receipt dated 12/10/2012, acknowledging receipt of fine amount of rupees 5,000. Full stop. The list of witnesses included 2 serving employees. No, included a bench assistant and the additional public prosecutor. In the so-called reply, in the reply to the so-called charge sheet, the petitioner, submitted on 1/7/2013, the petitioner had admitted that he had deposited the fine amount of rupees 5,000 in compliance of the judgment and order dated 15/9/2012, passed in Sessions case number 4/2011. Full stop. The petitioner had further informed that he had already preferred a criminal appeal before this court on 14/12/2012, and the same said a criminal appeal had been registered and numbered as criminal appeal number 169/2013. Full stop. As the said criminal appeal was pending on the date of submission of the reply to the charge sheet on 1/7/2023, the petitioner requested the disciplinary authority not to proceed further in the disciplinary proceedings on the basis of the charge sheet and had prayed for keeping the disciplinary proceedings in abeyance till the outcome of the criminal appeal, criminal appeal number 169 stroke 2013. Full stop, para. The criminal appeal, criminal appeal number 169 stroke 2013 came up for consideration on 25/7/2013. Full stop. Before the High Court, before the appellate court, it was submitted on behalf of the petitioner appellant that he could be released on probation of good conduct under Section 4 of the Probation of Offenders Act 1958. Full stop. In view of such prayer made on behalf of the petitioner appellant, the appellate court dismissed the criminal appeal. While dismissing the criminal appeal, provided had modified the sentence by allowing the appellant to go after execution of a bond to go. Probation is allowed to go on probation of good conduct after execution of a bond under Section 4 of the Probation of Offenders Act 1958 to the satisfaction of the learned trial court. After execution of a bond within a period of 4 weeks therefrom under Section so and so to the satisfaction of that. Full stop. After the order dated 25/7/2013 of the appellate court, the petitioner approached the learned trial court of additional session judge FTC Borpeta on 27/8/2013 and executed a bond seeking leave to execute a bond in terms of the appellate court's order. Full stop. The learned trial court consider the petition and the judgment and order dated 13/7, the order dated 13/7/2013 of the appellate court and allowed the petitioner to go on probation of good conduct after executing a bond under Section 4 of the Probation of Offenders Act 1958. Full stop. Para. In the In the above backdrop, comma, the disciplinary proceedings, which was initiated by the charge sheet dated 26/2013, had proceeded, comma, in the meantime, before the inquiry officer, comma, that is, comma, the additional chief judicial magistrate, comma, Borpeta. So the inquiry officer heard the presenting officer as well as the representative of the delinquent, that is the petitioner. Full stop. The inquiry officer took note of the fact that the petitioner had already been convicted and sentenced by a court of competent jurisdiction in Sessions case number 4/2011 under section 135(1)(a) of the Electricity Act by judgment and order dated 15/9/2012. Full stop. The inquiry officer also took note of the fact that the petitioner had already deposited the fine amount before the learned trial court immediately thereafter on 12/10/2012. And it was after the dismissal of the criminal appeal by the High Court by order dated 25/7/2013 with the further with the condition that the petitioner can be allowed to allowed to be released on probation of good conduct. The petitioner executed the bond on 27/8/2014. Also, the inquiry officer had thus observed that the materials on record on the basis of such materials on record, the only point that remained to be decided was whether the fact of releasing the delinquent on probation had diluted the offense committed by the petitioner delinquent and had mitigated his moral turpitude. Observing that the offense committed by the petitioner showed his total disregard and disrespect towards his duty to his official positions, as well as to the society. The inquiry officer, in his inquiry report dated 2/5/2016, had reached a finding that the act committed by the petitioner would fall in the category of offense involving moral turpitude. And the fact of his release on probation of good conduct would not mitigate his guilt. Post. Para. The inquiry report dated 2/5/2016 was thereafter forwarded to the petitioner by the disciplinary authority submitted by the inquiry officer on 2/5/2016 in DP number 1/2013. Was therefore forwarded to the petitioner, who was then working as the upper division assistant, was put to the petitioner on 22/12/2016.
Lord.
Asking the petitioner to furnish his comments on the inquiry report within a period of 15 days for taking further follow-up action as per law and rules thereof. Post up. The petitioner represented to the on receipt of the letter, on receipt of the inquiry report, the petitioner submitted a representation before the disciplinary authority
Date has not been given, Lord.
Hmm?
Date is not there, Lord.
Huh?
Date is not there.
To drop the disciplinary proceedings drawn up against him. Close stop. Para. The disciplinary authority concurred with the findings of the inquiry officer that the act committed by the petitioner would fall in the category of would fall in the category of offenses involving moral turpitude. Finding the inquiry report was accepted by the disciplinary authority, and the disciplinary authority was of the opinion that the case was a fit case for awarding penalty under Rule 7 of the 1964 rules. The disciplinary authority had observed that the fact of releasing the petitioner on probation of good conduct would not mitigate his guilt. And the disciplinary authority did not find any reason to entertain the representation submitted by the petitioner for dropping the disciplinary proceeding. Full stop. The disciplinary authority, who was also the appointing authority, had by the order dated 16/3/2017 imposed the penalty of stoppage of 3 increments without cumulative effect as per the provisions under Rule 7 within bracket 2 of the Assam Services Discipline and Appeal Rules 1964 upon the petitioner. And the said order, and the said order was to come into effect I have heard Mr. K. Sharma, learned counsel for the petition. Mr. Vijay Talukdar, learned senior counsel, assisted by Mr. P.K. Medhi, learned counsel for the respondent number 1, and Mr. N.K. Sharma, learned counsel representing Mr. H.K. Das, learned standing counsel GHC for the respondent, Guwahati High Court, for the respondent number 2, 3, and 4. Okay, we'll dictate the other part at 2 o'clock. Yes, madam. Which item? Please come this side.
My lord, I apologize, my lord. My lord, I'm not feeling well. Item 17, can it be only for the day, my lord? Item 17.
Yes, Mr. Sharma.
Lordship,
They have made the thing that you have not ever served any copy of the writ petition to them.
My lord, I was engaged lately. My lord, I will serve copy. My lord, tomorrow, not today. My lord.
Tomorrow you serve.
My lord, tomorrow I will serve.
In the meantime, if you want to file it.
Lordship.
It will be too late. Okay, MS S.J. Borua, learned counsel for the petition, heard. S.J. Borua, learned counsel for the petitioner, and Mr. Who is there? 17? Itu nih. Itu. Huh? Vijay Talukdar, assisted by P.K. Medhi for the respondent number 1, and Mr. N.K. Sharma, learned counsel representing Mr. H.K. Das, learned standing counsel GHC for the respondent number 2, to stop. The learned counsel for the respondent sides have submitted that they have not been served with the with copies of the writ petition and the annexes. So MS Borua has submitted that she would supply a copies of the writ petition along with annexes to Mr. Medhi and Mr. Sharma by tomorrow. Full stop. As sought for by the learned counsel for the parties, release the case after 3 weeks on a date to be fixed by the office.
Deeply obliged.
Obliged.
Petitioner retired.
Yes. He retired yesterday from the Baksha district.
Mr. Sharma, learned counsel for the petitioner, has submitted that since the by the as the learned appellate court by order dated 25/7/2023 had modified the sentence from fine of rupees 5,000 to release on probation of good conduct under section 6(4) of the provision of Offenders Act 1958. And there was no occasion subsequently and there was nothing adverse in the subsequent period, comma, the impugn order of the impugn order dated 16/3/2017 of the disciplinary authority is liable to be set aside. Full stop. He has further contended that the procedure prescribed for disciplinary proceedings under the 1967 rules were not followed during the course of the disciplinary proceedings. And as a result, comma, the disciplinary proceedings stood vitiated. Full stop. It is his further submission that the penalty imposed on the petitioner is disproportionate to the nature of alleged misconduct. Full stop. Mr. Sharma has submitted that in response, Mr. Sharma has submitted that a release of an offender on probation of good conduct under section 4 of the Provision of Offenders Act 1958 would not imply that the conviction has been removed. It is only the sentence which has been converted to a release of the offender on probation of good conduct. Full stop. As regards the procedure followed in the course of the disciplinary proceedings, he has submitted that there is no violation of the principles of natural justice. Full stop. The petitioner himself, during the course of the disciplinary proceedings, had admitted that he had been convicted and sentenced in a criminal trial. Full stop. As regards the submission advanced by the petitioner that the penalty is disproportionate, it has been controverted by submitting that the petitioner was earlier imposed a penalty of withholding of 3 increments with cumulative effect by an order dated 5/2/2011. Full stop. The petitioner had never challenged the said penalty, meaning thereby, he had accepted the said penalty. Full stop. It is the second occasion, the petitioner has been imposed a penalty under the 1964 rules. Full stop. Yes, Mr. Towler, anything? Okay, Mr. Talukdar, the senior counsel appearing for respondent number 1, has also submitted in similar lines. Full stop. And has submitted that he has submitted that the petitioner has already been leniently dealt with, and as such, and punishment in the present case is not harsh and disproportionate. First, I have considered the submissions of the learned counsel for the parties and have also perused the materials brought on record by the parties through their pleadings. First, which decision you cited, Mr. Sharma?
2010.
Pata likhibo.
Two
In support.
page 772.
In support of his submissions, Mr. Sharma has relied upon a decision of the Honorable Supreme Court of India in state of Uttar Pradesh. Versus Saroj Kumar Sinha, reported in 2010 to SCC 772. Yes, Mr. Sharma. Saroj Kumar, which one are your decisions?
Lordship, 1990, 90, 2 SCC 426 Lordship, Union of India versus Boxiram.
Next one,
And next one is Lordship 2010 8 SCC 573 Lordship. Sushil Kumar Singhal versus Regional Manager Punjab National Bank.
to buttress his submissions will give a format. The Mr. Sharma has referred to the decisions of the Honorable Supreme Court of India in Union of India and others versus Boxiram, reported in 1990 to SCC 426. And next is
2010 8 SCC 573.
the facts. I have also gone through the decisions cited by the Learned Counsel for the parties in support of their respective submissions. Full stop. There is no dispute to the facts already narrated above. Full stop. The petitioner was convicted of the offense under section 135 1A of the Electricity Act. And I put a select statement. And was sentenced to pay a fine of rupees 5,000, in default of payment of fine, to undergo simple imprisonment for a period of 2 months. Full stop. Section 135 of the Electricity Act is with regard to is an offense. No, no. Is an offense which prescribing 135 of the Electricity Act is with regard to theft of electricity. So as per section 135 1A, whoever, dishonestly, taps, makes so and so, so as to extract or consume or use electricity shall be punishable with imprisonment for a term which may extend to 3 years, or with fine, or with both. Full stop. The allegation against the petitioner was that he illegally connected he made illegal connection of electricity with for his house, residential house, with overhead wire through hooking. Full stop. The learned trial court, after appreciation of evidence, led by the prosecution, had reached the finding that the prosecution had established that the petitioner illegally connected the electric connection without making any payment, and the electricity lines were detected and subsequently disconnected by the officials of the ASCB. Full stop. When the petitioner preferred the appeal before this court, provide criminal appeal number 169/2023. That appeal came to be dismissed by order dated 25/7/2023. Full stop. It was on the prayer of the petitioner as the appellant that he could be released on probation of good conduct under Section 4 of the Probation of Offenders Act 1958, the appellate court had modified the sentence from fine of rupees 5,000 to release on good conduct on the execution of a bond. Full stop. For as per subsection 1 of Section 4 of the Provision of Offenders Act, court করে দিব। From a reading of the subsection 1 of Section 4 of the Provision of Offenders Act 1958, quoted above, it is evidently clear that the court having regard to the circumstances of the case, including the nature of the offense and the character of the offender, can release an offender on probation of good conduct if it is found expedient, instead of sentencing him at once to any punishment. Full stop. Thus, it is clear that when a court releases an offender on probation of good conduct, comma, the conviction part does not stand obliterated. Meaning thereby, the conviction part stands. Full stop. Which para? Para 28. It has been clarified. It has been observed in Sushil Kumar Singhal, Supra, to the effect that conviction in a criminal case is one part of the case and release on probation is another. Grant of benefit of the provisions of the Probation of Offenders Act 1958 only enables the delinquent not to undergo the sentence on showing his good conduct during the period of probation. It has been held to the effect that conviction of an employee in an offense permits the disciplinary authority to initiate disciplinary proceedings against the employee or to take appropriate steps for his dismissal stroke removal only on the basis of his conviction. An employee cannot claim a right to continue in service merely on the ground that he had been given the benefit of probation under the 1958 Act. পুরাটো লিখে দিব। The Honorable Supreme Court in Paksiram, Supra, has held that A court, while invoking the provisions of Section 4 of the Probation of Offenders Act 1958, does not deal with the conviction, semicolon. It only deals with the sentence which the offender has to undergo. Instead of sentencing the offender, the court releases him on probation of good conduct. The conviction remains untouched, and the stigma of conviction is not obliterated. Thus, it is clear that in the case of the petitioner, here, with the release of, with his release on probation of good conduct pursuant to the order dated 25/7/2013 of the Appellate Court. The conviction of the petitioner under Section 135(1)(a) of the Electricity Act did not get obliterated. Full stop. Moral turpitude means anything contrary to honesty, modesty, or good morals. Full stop. It has been held in Sushil Kumar Singhal, Supra, that conviction of a person in a crime involving moral turpitude impeaches his credibility, as he has been found to have indulged in activities opposed to honesty. Full stop. The petitioner herein was serving in the establishment of the respondent number 3 at the relevant point of time, and an indulgence of the petitioner in an act of theft of electricity is clearly an act involving moral turpitude. Para The disciplinary proceeding against the petitioner was initiated only on 26, 2023. Only after his conviction and sentence, only after his conviction by the judgment and order dated 15/9/2012. Close to. Proviso 2. Proviso A. In an analysis of the provisions of Article 311, within bracket 2, within bracket small a, goes to show that the constitutional guarantee of 3 stages it has been held in so and so 1976 3 SSC 190. To the fact that proviso small a to Article 311(2) dispenses with all the stages of disciplinary proceedings when an employee is convicted on a criminal charge. The reason for the proviso is that in a criminal trial, the employee has already had a full and complete opportunity to contest the allegations against him and to make out his defense. In criminal trial, charges are framed to give clear notice regarding the allegations made against the accused, secondly, the witnesses are examined and cross-examined in his presence and by him alone, and thirdly, the accused is given full opportunity to produce his defense. It is only after hearing the arguments that the court passes the final order of conviction or acquittal. In these circumstances, therefore, if after conviction by the court, a fresh departmental inquiry is dispensed to it, it will lead to unnecessary waste of time and expense and a fruitful duplication of the same proceedings all over again. Full stop. It was for this reason that the founders of the Constitution thought that where once a delinquent employee has been convicted of a criminal offense, that should be treated as a sufficient proof of his misconduct, and the disciplinary authority may be given discretion to impose the penalties referred to in Article 311(3), namely, dismissal, removal, reduction in rank. It is clarified that Proviso A to Article 311(2) is merely an enabling provision, and it does not enjoin or confer a mandatory duty on the disciplinary authority to pass an order of dismissal, removal, or reduction in rank the moment an employee is convicted. The matter is left completely to the discretion of the disciplinary authority, and the only reservation is that the disciplinary inquiry contemplated by the provision, as also by the rules, can be dispensed with. Full stop. The rules involved in the case in hand is the Assam Discipline Services Appeal and Discipline and Appeal Rules 1964. Full stop. It is to be borne in mind that the disciplinary authority in the case in hand did not proceed to impose the penalty of either dismissal or removal or reduction in rank. It has imposed the penalty of stoppage of 3 increments without that too, without cumulative effect. Full stop. Moreover, in the course of the disciplinary proceeding, the petitioner had himself clearly admitted about his conviction for the offense under Section 135(1)(a) of the Electricity Act. Full stop. Moreover, after the inquiry report, submission of the inquiry report, the inquiry report was duly forwarded to the petitioner, asking for his representation, asking for his comment. Full stop. Only plea advanced by the petitioner in his representation was that it would be harsh if any penalty was imposed. It was submitted that since he was released on probation of good conduct, the disciplinary proceeding initiated against him was to be dropped. Such a plea cannot be countenanced in view of the settled position of law, as alluded herein above. এটা কেন্দ্রীয় বিদ্যালয় সংগঠন ভার্সেস জে হুসেন বুলি আছে চাওকচোন। কেন্দ্রীয় বিদ্যালয় সংগঠন ভার্সেস 0%. But with regard to the contention that the penalty imposed upon the petitioner is harsh and disproportionate, comma, it is found that the petitioner was earlier visited with a penalty of stoppage of 3 increments with cumulative effect by an order dated
5/2/2011.
5/2/2011. Full stop. The petitioner did not challenge the said imposition of penalty. Full stop. If a disciplinary authority decides to inflict a punishment of stoppage, penalty of stoppage of 2 increments, withholding a stoppage of 2 increments, what is the penalty in the 1964 rules? Withholding of increments, withholding or stoppage of increments, comma, the disciplinary authority is also required to decide simultaneously whether or not the withholding stroke stoppage of increment will have a permanent effect on the future increments. If it is decided that the withholding of increments will not have any effect on the future increments, it will have to be mentioned in the order that the increments stroke are withheld or stopped for the specific years without cumulative effect. In such a case, comma, the employee cannot draw his increments for the said specific years which are otherwise due, and after expiry of the specific years, he will draw his increment, he'll draw his increment. Full stop. If it is decided to withhold 2 increments with permanent effect on the future increments, comma, the orders contains that the increments are withheld or stopped for the specific number of years with cumulative effect. In the second case, the employee draws his increment after expiry of the specific years and with wiping out of the increments of the years in the interact number. Post-op. In the case in hand, comma, it is the penalty. No, sorry, the petitioner has been imposed the penalty of withholding stroke stoppage of 3 increments without cumulative effect. Zero. It is settled that the question of the choice and quantum of penalty is within the jurisdiction and discretion of the disciplinary authority. Full stop. It should not be so disproportionate to the offense as to shock the conscience and amount or conscience. Full stop. The doctrine of proportionality the High Court, sorry, in exercise of its extraordinary and discretionary jurisdiction under Article 226 of the Constitution, this court, exercising power of judicial review, can only examine whether the penalty imposed upon a delinquent is so harsh and disproportionate, is harsh and disproportionate as for shocking the conscience. Full stop. The court cannot act as a disciplinary authority and impose a particular penalty. Full stop. Having regard to the entire fact situation obtained in the case, the court is not persuaded to reach a view that the penalty imposed upon the petitioner is shockingly harsh and disproportionate. Full stop. Para. In view of the discussion in the book and for the reasons assigned therein, this court finds that the present writ petition is bereft of any merits and is liable to be dismissed. Most of it is accordingly dismissed. There shall, however, be no order as to cost.
Deeply obliged, Judge.
Okay.
Item number 8.
Please, my lord, the respondents 7 and 8 supposed to file affidavit. I think with my land right. As per order dated 9/10/2023.
They can argue because I question the maintainability of the petition, my lord.
Maintainability.
Because it is a matter of whether he is questioning three policy, my lord, LIC policy, which which we are the nominee, my lord. Now, part payment also made from the policy. Now, whether this court going to decide the policy because it has to go to the civil court to question the challenge the policy, my lord.
Nomination is?
We are the nomination. Son,
You are?
mother.
My lord, I am the wife of the deceased, my lord.
Actually, it should go to, you should approach the proper forum.
My lord, that succession certificate.
Yes.
Right, my lord, that,
Yes.
and what only thing is that, my lord, the policies with them, now policy with the LIC for claiming. So if we go for succession also, my lord, that is some document is required. Only somehow we able to
We
get
can
a,
pray for it.
Some document means what?
that's my policy. We have only the, my lord.
If you are a wife, what more is required to obtain succession certificate? Huh?
My lord, LIC, my lord, that policy is not with us, my lord. Only one policy photocopy, the other is, my lord, the premium paying receipt is with us, my lord. So already they have deposited, my lord. As per the, my lord, they are the nominee, my lord. As per the, my lord, succession, my lord, I am entitled at least 50% mother and I, my lord.
Who are
If they
the
agree, my lord.
nominees? Who are the nominees?
The brother and the wife,
Mother.
mother.
Are you open for any settlement?
Well, she is got a government job in the meantime, my lord, and she got all the pensionary benefits. But these are the policies which are in.
That cannot bar
mother and
me.
brother.
That cannot bar me.
Of course,
Otherwise, your role is to discharge. Otherwise,
yes.
Mr. Roy, your role is to, as a nominee, is it will be given to you by the LIC as a valid discharge of the policies.
Right,
You do not have the right to sit over the money.
right. But then, my lord,
It is the legal heirs who are entitled.
like mother is also class 1 here, man.
Right. So why don't you, brother, he is not, why don't you get into something
My lord.
instead of going into long drawn litigation?
Will work out, my lord.
This, otherwise this court can put stay on everything till the succession is decided.
Right.
I think mother and wife should
My
sit
lord.
together.
Entitled.
You leave out the brother. What right he has? He is not class 1.
No, yes.
And what is the nominee, what is the position of nominee in the eye of law?
It's a custodian, my lord.
Custodian. Then whether this court has power to bind you?
That is what, my lord, I was saying that. my lord.
Yes, I can bind you. On trust, you will keep it in a fixed deposit.
Yes, still until it's decided.
Until it is
Until succession
decided. Otherwise, if the mother and wife sits together, comes to a formula, it is always better.
Only three.
I don't know. Otherwise, all the options are available before this court. Wife and mother fighting.
Part withdrawal of the amount also, my lord. Because before they come to the court, the money has been discharged, my lord, part payment.
33 lakhs they have withdrawn.
Huh?
30 lakhs have been paid to them.
13 lakhs.
33 lakhs.
33.
33.
And what remains?
Remains with the mother's name, my lord, that last, when the order was passed, 11,56,941 was kept in hold. And also from the brother, whose 15 lakhs has been hold, my lord.
What are the, let us see, their LIC's affidavit.
Yes.
The LIC filed an affidavit, my lord. They have not saying, my lord, they only saying. that-
You are not approached for succession.
My lord, initially, my lord, we approach the LIC, my lord, when they process to pay, then we approach the loan. I will go for my deed, my lord. Till then, my lord, that I may protect that arrest of the amount will not disbursed to them, my lord. Or if they are agree, my lord, that mother and the wife is entitled, my lord, then they can, my lord, settle the issue also. my lord.
Mr. Roy, you can explore that possibility. Mother and wife. It is up to you.
Let a date
And
be
since
given.
you are not filing any affidavit also.
Let a date be given, my lord.
Huh?
Date be there. After 2 weeks or 3 weeks.
You can explore. Mother
will-
and wife, definitely. Are you open to the idea of not
My
sharing
lord,
something with the mother?
My lord, specific, mother is entitled, my lord. We are not denying. my lord.
Okay. Heard Mr. M. Soronia, learned counsel for the petitioner, and Mr. J. Roy, learned senior counsel, assisted by Mr. R. Ajorika, learned counsel for the respondent number 7 and 8. Full stop. Any LIC counsel?
That's number 1 to 6.
Okay. Also heard Mr.
L. Mondal.
Mr.
L. Mondal.
Your name?
Yes.
Yes?
Alam.
Alam. Learned counsel representing Mr.
L. Mondal.
A.L. Mondal for the respondent LIC authorities. Full stop. The petitioner here is the wife of one late Rajiv Borua, whereas the respondent number 8,
It is the mother.
7, and the respondent number 8 are the brother and the mother respectively of late Rajiv Borua. Full stop. The bone of contention between the contesting parties are 3 LIC, 3
LIC policy.
3 LIC. policy.
3 LIC policies. Full stop. The petitioner, the marriage of the petitioner with late Rajiv Borua was solemnized on 28/4/2022 under the provisions of the Special Marriage Act 1954. Full stop. The late Rajiv Borua, during his lifetime
Well,
and prior to his marriage,
marriage.
nominated his brother, that is the respondent number 7, and his mother, that is the respondent number 8, as nominees in those 3 LIC policies. Full stop. Mr. Oronia and Mr. Roy have submitted that the parties would explore as to whether an amicable settlement
No.
between them can be arrived at. Full stop. In such view of the matter, they have sought for or before mediation.
Mediation.
Huh?
Mediation.
They have sought for sending the matter
Well,
to the Guwahati Mediation Center, Guwahati High Court.
Right.
Full stop. কি আছিল তো কেনেকে কৰে দিয়ে না mediation mediator. Okay. The
Lordship will fix up a date, my lord, so that they can appear.
the parties will appear before the এইটো কি পঠাই দিব লাগে নেকি mediator appoint কৰিব লাগে নহয় কি করব লাগে? হ্যাঁ? Okay. কোনে করে coordinate. Okay. The parties will appear before the mediation center, Guwahati High Court on
20, my lord.
20/03/2024. Full stop. This order is to be brought to the notice of the coordinator of the Mediation Center, Guwahati High Court, for appointment of an arbitrator.
Mediator.
Mediator. Etu heri likhibo, etu 11 AM likhi dibo, on 11 AM. This order is to be brought to the so-and-so notice, huh? List the case. On 8th of April or 9th of April.
8 of April.
8th of April, along with the report of the mediator.
Mediator. Final.
Number 9. This matter is that eviction, my lord, Lordship has granted, my lord, a interim direction not to, my lord, disturb the position of the petitioner. But subsequently, my lord, on 20.
How much time will take?
Some time we require, my lord, because.
How much?
No, but today your lordship will find at least that issue can be, my lord, settled in the order dated 22/1/2024. Paragraph 9.
Since the entire petition is there, we will decide. In the course of opinion is.
Another aspect that will also be, my lord, important to look into, because, my lord, I am alleging that the non-compliance of the order, rather violation of the court's order, my lord. And therefore, my lord, in the order dated 22/1/2024, lordship has observed this way, my lord, in paragraph 9. Since the petitioner side has alleged non-compliance of the direction made in the order dated 19/1/2024, this court is of the considered view that before proceeding further with the writ petition, an affidavit from the respondent number 3 in respect of the statement made in letter dated 21/1/24 appears to be necessary. The said affidavit shall address on the issue on compliance of non-compliance of the direction made in the order dated 19/1.
Did you file any
Yes.
contempt petition?
They have filed an affidavit in opposition.
Did you file any contempt petition also? No.
My lord, contempt has been filed now, my lord, after receipt of this affidavit. And they have filed the affidavit in opposition.
Mr. Pathak, you have filed your affidavit?
Yes, Your Lord.
Detail affidavit also?
Both have, we have filed. And
Detail also?
Detail also. Detail was filed on 1/1/2024. And this affidavit was filed on 5/2024. Lordship, perhaps the issue.
19/1/19/12/23. Your lordship will find in that order, my lord, it was stated that, my lord, on instruction.
Let us see now, we'll see
Lordship.
your case setup.
Yes, sir.
First, we have to see your case setup
My lord,
by you.
my case is, my lord,
On the basis of what kind of
in-
documents?
in a nutshell, my lord, yes, my lord. It had to be filed, my lord, heard.
Because I think this was moved very unlisted.
Lordship, my lord. It's, unlisted, because there is no, my lord, notice. There is no notice, only a, my lord, purported notice was issued, my lord. Directing us to, my lord, vacate the place. That notice is at, my lord, 101, my lord, of my writ petition, my lord.
How many petitioners?
Total 87, my lord.
What kind of supporting document you have?
Yes. My lord will find. I have, my lord, given. my lord,
Where
this-
from we can understand that, yes, you are in occupation of this specific land.
Your lordship had posed the query that what were the coordinates of that forest? Yes,
That I
that
have-
we have brought on record.
That is why I'm
Yes.
asking Mr. Soikia
Lordship.
that where from we can ascertain that these petitioners are in occupation of specific plots of land.
One of the specific, is not there, but.
See here and there,
My lord, we are saying we are not in the forest land, first of all, my lord.
how to substantiate
Yes.
that.
But that is admitted by them. Though, my lord, on 19 1, it has been said that, my lord, they are making the eviction.
Admission, where is that admission?
No. they
That
are-
will close the issue.
Yes,
Yes,
lordship may
That
grant
will
us the
close the issue.
liberty.
Where is that?
Yes, my lord, lordship, the affidavit in opposition, lordship, they have filed, my lord.
Huh.
In fact, that is what I want. Lordship may grant us the liberty to conduct an eviction process in the area which is within the coordinates of this notification. That is all I want. Nothing else. If they are not within the area, they won't be affected.
No, what is
Lordship
that?
may specify that this is the area.
If you are outside, if your claim is that if you are outside the forest area,
It is admitted.
then
by
I
them.
had asked specifically on the first day itself
Yes,
that produce the coordinates
Yes.
of the forest
lordship. They have given.
declared under Assam Forest Regulation.
Lordship.
If coordinates are available, I think one mobile is enough.
Yes, lordship may
Is
specify.
it not?
Yes, your lordship.
One good mobile is enough.
Yes, your lordship. Nowadays.
Yours land of plot of land. Get the mobile coordinates. Verify with the coordinates. As easy as that. Not required to
No, yes, your
go
lordship.
to this deliver a
Yes,
long
no,
exercise.
No, my lord. will-
Are you ready for that?
My lord, yes, I am ready for that, but here. my lord-
Coordinates with coordinates.
Very well.
No, my lord, will can you see the statements and the notification what they have issued?
We are into your statement is
No, no,
you
not
are-
my statement, their statement.
no, your statement is outside the forest area.
Lordship.
Their statement is inside the forest area.
Not that, my lord. That's what I'm saying. They are also saying it is adjacent to the forest area, the notification that has been.
So let us get your stand vindicated.
Yes, that's what I'm saying. And no. Lordship-
Vindicated.
Lordship will
In fact,
kindly see,
lordship
my lord.
will give us
My
that.
lord, here the major issue, my lord, firstly, my lord, we have been evicted, my lord, although my lord order was passed on 1928, they have been evicted as well. So we have brought to the notice of this court, my lord. The first question, my lord, this is.
We are going into larger issue first and we'll deal with
I
that
think,
issue.
my lord,
We'll deal with that
My
issue.
lord, disrespect to the court's order is also, my lord.
That
equally
we'll
important.
see.
Yes.
That you are not to decide. The court is to decide.
Lordship, my lord. So therefore, my lord,
That
I'm-
jurisdiction is exclusively
to the court.
to the court.
Lordship, my duty is to point out.
So
my lord,
moto, yes,
Lordship,
I am quite aware of it.
Lordship, my lord. So. my-
I'll take care of it if required.
Lordship, my lord.
Right now, firstly, the question is, your claim is clear that you are outside the forest area.
Yes,
That is why I asked on the very first day
Lordship.
that get the notification.
Yes,
Now they have the notification, perhaps.
yes.
Page number 126, your lordship. It's a part of our affidavit.
126.
126.
That is in 1966.
Yes,
Forest. This is section 17,
yes.
not section 4 or section 5.
Now, your lordship.
Am I clear?
No, my lord will come to page 1.
Am I clear?
Yes, yes, my lord. That's what. I'm
And
saying.
Mr. Pathak,
Lordship.
one more.
Lordship.
When the section 4 or section 5 notification,
Lordship.
section 4 or section 5.
My lord, before that, my lord, may.
Let me have the facts. Then I'll be able to understand more. Do you have any idea when section 4 or section 5 notification was done?
I do not have that instruction today, your lordship.
Because that will take care of 2 generation, 3 generation,
Yes, your
everything.
lord. That.
My lord, this particular notification.
My learned friend is
this particular notification, it itself excludes our area.
Good enough.
Yes, ma'am, that's what I would like to point out before your lordship.
So then we can ask both you,
Yes.
Deputy Commissioner and Forest, Divisional Forest Officer to
Yes.
go for a joint.
We are,
Yes, where is State
Madam,
Mr. Borua?
Issue is not, madam, no doubt, madam, what I am on, my lord. In and my lord, most.
See, Mr. Borua, Soikia,
Lordship.
we're into that only. If you are bona fide claimant of non-forest areas, this eviction exercise is totally wrong. And since your assertion is that you are in non-forest areas, beyond the forest areas, you'll stay.
My lord, what I am on, my lord, I asserted that I am outside the forest area, and in their affidavit, they have admitted we are outside the area. In the notification, our village is not included. This is materials available on record, and notwithstanding the opposed order, they have evicted us.
Then
They have
you
demolished
ask
our
for
houses.
1,000 crore damage before
No,
the
my lord, I am filing an interlocutory application for a.
file a damage suit for
I-
seeking damage of 100 crores from them.
My lord, I am.
We are not into disputed facts, Mr. Soikia.
No, there is no dispute, my lord.
Where is that admission?
Yes, my lord.
Please.
Yes.
Please,
The affidavit in opposition, lordship may come, my lord.
please.
because the order of the division bench also was to only carry out a eviction process
Paragraph.
of
my
this
lord,
reserve forest.
my lord, that,
Because we are doing it pursuant to directions of the division bench.
not at all, my lord.
So, no, I have,
Not at
I have
all.
placed that,
No, one by one.
Yes, ma'am.
I have placed that order on record.
No.
The order of the division bench was to carry out an eviction process, or rather to make the area of the reserve forest free of encroachment. So our mandate, your lordship, is to make the reserve forest.
Okay.
So if they are outside that area, your lordship, we anyways.
Okay, which
Yes.
part? Which paragraph they have
Lordship,
admitted?
in paragraph 5,
Of
they have said. that they
paragraph
ha-
5
Paragraph
of
5
their affidavit
but at page 103, my lord.
103.
Section 5 was from 1961.
Paragraph 5, my lord. There they said, my lord, this eviction drive has been carried out pursuant to the, my lord, order in the PIL, my lord. And secondly, my lord, they have committed in the, my lord, contempt petition that they'll carry out the eviction within a, my lord, fixed time.
No, no, where is that admission?
Yes. My lord,
They have admitted that you are outside the
Paragraph-
forest area.
Paragraph 7. That therefore the aforesaid eviction plan in Kamarkhali RF Lakhipur Res is proposed in compliance of the aforesaid area of this honorable court after joint survey and verification of revenue and forest authority of Goalpara district. It is pertinent to mention here in that Kurshapakri is an adjacent village of Kumarkhali Reserve Forest and no individual having record of right is being evicted in the proposed eviction. It is adjacent village. It is not within the reserve forest. And secondly, the notification, your lordship may see, my lord. Page 127.
Now, show me then, one more.
Page
idea.
127, lordship, my lord, this, at least this one, my lord, lordship, may kindly have a look and
Okay.
then we'll proceed it. 127.
Yes.
My lord, on the left-hand side, down below the two lines, the demarcated boundary from pillar number 41 to pillar number 46 and excluding the paddy field. These two pillars, number 46 at building 280 at distance of so-and-so, there to pillar 47 at bearing number so-and-so at a distance of 2502 Thaler, excluding the Kursapagari village area.
Okay, show me then that Kusa Pakri village and
Village
Kusa Pakri
we-
part 2 are the same village.
Yes,
Show me revenue village, Kusa Pakri village and Kusa Pakri part 2 are same revenue village.
Malad, that immediately at this stage I cannot give, but then at that time perhaps there was no part one. or
There
part
could be,
that-
yes.
That, for that I have to.
Where from Kusa Pakri revenue village, if it is in the revenue records of deputy commissioner, absolutely no doubt.
So this is the
Then-
Kursapakri village has been kept out.
Kept out, right?
Subsequently, this Kursapakri 1 or 2 might have been created or.
Because if revenue village, your revenue village is under,
It is not said revenue village. It is Kursapakri
all
village
these
area.
petitioners are Kusa Pakri part 2. You are saying yourself, you are proclaiming yourself,
Yes.
right?
Yes.
Where from you have got this Kusa Pakri part 2?
These area.
That's all.
So for that,
That's all.
I have to obtain instruction.
Nothing more, nothing less.
For that, I have to obtain instruction.
The source of Kusa Pakri part.
Yes,
two.
whether this Kursapakri has been bifurcated.
If it is
1 or 2.
revenue village
But it's a
and-
village.
or revenue village and in the revenue records, right? Then the provisions of Assam Land and Revenue Regulation will come. Assam Forest Regulation will not have any place. Then DFO, Principal Chief Conservator of Forest, they have no authority,
No.
right? And if Kusa Pakri is revenue village, matter is there.
That's what I'm
It
saying.
is in the record of revenue, good enough. That's all. There is nothing. But if Kusa Pakri is not a revenue village, part 2, and inside these coordinates,
No, this Sitha I have annexed in that area where it is reflected Kursapakri 2. Sitha I have annexed with my read petition.
But perhaps there.
At page 46, my lord of my registration. Page 46, my lord. Updated petition.
this pertains to how many petitioners?
My lord,
Except for one name, your lordship, I could not find the others. One name, Jamaluddin, perhaps
Jamaluddin,
petitioner
my lord.
number 11.
Then my lord, 47, petition number 8, then my 48, 8, my lord. Then page 49.
See, if it
petition
is
number
prima
8.
facie, few of the
Seven.
petitioners
My lord.
having some land documents.
Gotcha.
Otherwise, it is also clear from page 52. This is all Bedokoli Jorimona.
No, it's a government land, my lord. We are not saying
Huh?
that, we are not saying that it is not government land. It is government land, but not forest reserve, my lord. So the authority at all, it has to be exercised by the civil administration, my lord, revenue authorities. My lord.
Then Kusa Pakri part 2 is revenue village. Get it from revenue records.
No, no, this is part of my lord, revenue record, my lord, 46, my lord. To show that it is not within the forest. My lord. And they have admitted in the my lord, affidavit that it is adjacent village of the reserve
No,
forest.
that is Kusa Pakri.
No, my lord,
That is Kusa Pakri. I will not take that.
no, the affidavit.
That notification. That is Kusa Pakri only. Kusa Pakri, yes, there is one Kusa Pakri. Whether your Kusa Pakri part 2 is
Same or no?
of part of Kusa Pakri, then you are out. You are out of forest land.
No, my lord, they.
See, we sitting here, we cannot decide. You have to give us conclusive material.
My lord, with all respect, my lord.
Otherwise, joint verification has to be carried out. We will not decide individual
No,
claim.
that part, obviously I'll have to cooperate and I'll be definitely cooperating for the my lord, exercising the
It is-
recovery part. Done.
It is
That is one.
private interest, also public interest.
Public
both-
interest.
Both.
Yes, my
It
lord.
cannot be denied.
I'm not denying that, my lord. That is true, my lord. But then, my lord, another issue, my lord, on 19/1/2024, this court having directed.
That is, please don't repeat that submission.
On the.
Because that is our jurisdiction.
No, only one paragraph contention, I'd like to draw your lordship attention. I'm just pointing out, my lord, paragraph 9, my lord. Paragraph 9, my lord.
You've been taking me by, time and again to that.
No, because this paragraph 9, I haven't, my lord, pointed out to your lordship, my lord. Page 105, my lord. The conduct of that particular DFO, my lord. But audacity of that officer, my lord.
That I have seen.
Lordship.
I am taking note of.
Lordship. Lordship will see, my lord, that on 19/1/24 at around 4:30 PM, the deponent was informed by the Standing Council, Forest and Environment Department that some restraint order against the proposed eviction has been passed by this honorable court in present writ petition, and the copy of which would be forwarded to the deponent as and when same is made available in the website of this honorable court. Accordingly, deponent waited for a copy of the interim order dated so and so, which was not made available to the deponent either by the Standing Council, Forest or by the petition. So, my lord, they have in the morning next, they have evicted. They have the specific knowledge of the order, my lord.
Oh, you are basically asserting the rights of the petitioners, or you are against the DFO? First,
No,
tell
my
me.
lord, both.
Tell me.
My lord, both, my lord. Because first is.
Then I choose to decide the petitioner's right.
Lordship, my lord. Lordship, my lord. My duty.
I'll
was to
take
point
care
out-
of
Lordship.
that part.
Lordship, my lord, it was my duty to point out before. Lordship. So I have
I'm
pointed
quite
that I.
aware. The order I have passed, I'm quite aware of it.
I'll not go into that, my lord, anymore, my lord, but. So
But
first-
you show me that Kusapakri Part 2 is part of Kusapakri, or Kusapakri Part 2 itself
Is a
is a
separate village.
revenue village.
This.
Lots of things happens. Court is not oblivious of that. So get it through conclusive material.
Yes, my lord, the queries that your lordship has posed, my lord. that I
Because
have- I have-
notification says Kusapakri is out of
Out of the village.
Out of the
village.
Now, only.
Now we have to see
That this Kusapakri part
part 2 is either part of Kusapakri, original Kusapakri village, or it is a separate village and outside the forest area. Either of the two. That is all. And if you are interested for joint verification with the
We have no-
DFO and Deputy Commissioner,
We have no difficulty.
that is the most, you are confident of your right.
No, I'm confident, obviously, my lord,
Then
there is documents,
we have
my
no
lord, much more documents are there.
They
which
are
can
also
show,
having
but-
no
but
difficulty.
With, my lord, thing is that as on today.
And we'll keep this about the DFO.
Yes,
As
that
That
issue
is
has to be
a
decided.
matter to be taken care of by this. You don't have to submit on that.
I'll not submit, my
But-
lord, as on today, my lord, as on today, my lord. We are all the, my lord, shelterless, my lord, without a roof, my lord. Because everyone has.
So
this is
15 days, we can do it.
They are, my lord, that aspect also lordship will consider human beings, my lord, and their documents have been shown, my lord. Document have been shown.
So that is why
50,
to
60
take,
years they are there, my lord.
to take better care of that official, I think a joint inspection is the most relevant thing.
And if he has indeed carried out an eviction outside the forest area, that would be very serious.
Then it will be a very serious thing.
Yes.
Then we'll take
That-
suo moto. We might
Yes.
drop a suo moto contempt.
If he has gone outside that, because even the division bench judgment is clear, your lord. He is not supposed to do it outside that forest area.
So let us have a joint verification.
Let this writ petition be pending, my lord. Let there be joint verification. Let
Very
this
well.
writ petition be pending. And the interim to be continued.
Lordship wanted that notification.
I had got, but since it's been shredded, my lord, it's 1961 section 5.
61.
60. My lord, kindly have a look.
61 means that is 4 or 5, section 4.
Section 5, my lord.
Section 5. After, because it is section 17 is in 1966. That completely rules out any right.
Generational rights will be.
And it is also settled that as soon as section 4 or section 5 is issued, from that day onward, everything is wiped out.
Yes, sir.
Something has to be proved before 1961. I am indicating to you.
Yes, sir.
If you are inside the forest area,
We are not, that is.
by chance, then you have to show your document before 1961.
Yes.
1961.
61.
Yes, Mr. Borua. You are part of it?
Yes, we are part of it. The major.
Lordship,
Major care has been taken
just,
by the
just for your lordship's attention, recently similarly placed petitioners had approached this honorable court. Their claims were for reserve. In fact, almost 536 petitioners were there. Their claims were somewhat similar that though reserve forest was separate, that petition was disposed of in these lines, Your Lordship. Okay, paragraph number 3, Your Lordship.
Which one?
Paragraph number three, and there they stand that as far as the reserve forest or proposed reserve forest is concerned, the activities of the forest department have to be confined to that area only, Your Lordship.
Or Mr. Soikia, we can propose that each of the petitioners can file an application, individual application, stating their supporting claim. Then that will be considered. That can be done till that is not disposed of by speaking order.
My lord,
That will be.
let there be the joint verification as your lordship has proposed. Let there be a joint verification, my lord, district administration forest and.
That will take time. Individual application, you'll submit,
my lord,
because group things are very difficult.
My lord-
Each of the petitioner, giving each of the petitioners.
Yes, my lord, kindly hear me, my lord. Here, what I, my lord, I have filed also an, with, I for restoring back the possession to me, my lord. In the event this court finds that my eviction was illegal. So that is there here, my lord. So once, my lord.
We are not expanding the scope of this writ petition, we are limiting the case to these petitioners. Right?
But
Each of the
our eviction-
petitioners, I have disposed of many cases. These 87 petitioners would be afforded opportunity to file individual claim application along with their supporting documents that they are outside the forest, reserve forest area, and DFO will examine their claim vis-a-vis the notification and the supporting documents, pattas, revenue receipt, everything, along with revenue records in consultation with the deputy commissioner. And thereafter pass a speaking order in each individual case. We can do it. Every petitioner will get the opportunity.
Lordship, obviously, my lord, lordship can pass an order, my lord, as your lordship deem fit. in the
No,
case,
no,
my
your
lordship-
every right will be protected.
My lord, my submission would be, my lord, while a court's order is standing, my lord, I have been evicted illegally. And my lord, there are decisions, my lord, to show that, my lord, once you are illegally evicted and it is proved, my lord, they have to be restored back. That is.
Then let the matter be listed. You are not interested in disposal of that. Heard Mr. P.
We are facing some urgency.
Council for the petition, Mr. KP Pathak, learned.
Joint verification. should be-
So learned standing council forest department is the case in the next.
Lordship, may I then pray that liberty may be granted us to at least go forward with the Lordship.
I am trying to protect everybody's interest.
Lordship.
Next,
May I pray for a short date, Your Lordship?
next Wednesday,
Very well.
next Thursday. Next Thursday.
Yes,
The
because that-
interim order passed, let's accept it.
Deep-
Next Thursday.
Thursday, my lord, will be,
Next week.
Because the contempt petition will be listed next week, Your Lordship. That,
Thursday?
very good. Thursday is,
but can it be on 13th, my lord, or 12th, my lord?
March.
12th of March.
Or it can be on the 5th also if your lordship.
No, I'll be-
Fifth.
No, I'll be not here, my lord. I'll be in outstation.
12th, then some observation from your lordship in today's order that
What?
because the contempt petition is to be listed next week, that the eviction, that lordship will.
Fifth, then fifth, seventh. Seven. Interim order. Continue.
Have been.
I will repeat for you.
12th, my lord. Item number 11, my lord, 12 would have been convenient for me. my lord.
They are saying that they are
they are-
facing, because I am
but that-
interested in disposal of the petition.
My lord, they are.
Securing your rights.
Yes, that can be done, that order.
You are so confident.
Entire, my lord, this exercise has been done only to, my lord, save themselves from the wrath of that particular contempt case.
I will say that if after the speaking order, petitioner is vindicated in their stand, the petitioner will be at liberty to file application and bringing to light the alleged contemptuous action on the part of the DFO.
Let it be on 5th, my lord. Let it be on 5th. Let it be on 5th, my lord, as you like.
Okay, fifth. Seventh, you are not available.
Oh, my lord, 7 lordship.
I propose 7.
Very good. I'll not be available, but he'll take, my lord. Any. Item 11. The interim order passed again.
Yes. Mr. Tadler, PP is not available.
Any other day, short that lordship will give money.
That way change your roster also.
In fact, lordship is
Okay, we keep it for further hearing. As if it changes, he'll make the effort to get it listed whenever it is convenient. Next week, we are saying.
next week.
Mr. S.K. Taldar, Learned Counsel for the Petitioners is present. So Mr. the Learned Additional Public Prosecutor for the respondent state of Assam is found absent to be on post of in view of absence of the Learned Additional Public Prosecutor, let the case be listed in the next week. For further consideration. For further consideration. When is your next day?
Next day, one date is gone.
No, so that day he said longer date has been taken.
Yes.
21. 21.
Earlier date gone.
Okay.
Item
Well,
12. Item number 12.
There is no representation. Mr. Burua, what is the matter?
Matter is with regard to mutation.
Mutation
Yes.
pending for 8 years.
No,
Too
in
much.
fact, because of that mutation case, that compensation amount was in dispute, that could not be disbursed because one portion of the land has been gifted over, and from there onwards, the acquisition has been done, and the compensation has been given as regard that. But since there was a
No
mutation,
stay.
yes,
So can you get fresh instruction in anything about this?
because these are the
If
old
some-
records I could make out. Yes,
Something is compensation is already disbursed.
Because there was a stay for which, yes, there was a stay for which that compensation amount was not disbursed.
Who is stay? Item 12, no stay.
Stay in the sense, because of the pendency of the mutation case. There was a
Pendency of the mutation.
Mutation.
When mutation is, suppose it is already,
It may,
mutation proceeding is not. 1 minute,
not-
1 minute, 1 minute. No, Mr. Borua. Your affidavit, now I remember.
yes.
Your affidavit, sorry, Did you file any affidavit?
Respondent fee.
Private respondent.
Yes.
Yes, yes. Hmm. Before filing this repetition itself,
This was
mutation order is
close.
closed.
Maybe the petitioner.
See his paragraph. See paragraph 15. If you have this affidavit.
I have it.
Respondent number 4.
Paragraph number 15.
15.
I don't have this.
Answering respondent just submits that since the mutation order was passed much before passing the order of granting probate by district judge, the petitioner had ample opportunity to challenge the order of mutation. If he actually agreed with, then paragraph 9, ultimately on 3/10/2015, the learned circle officer, Sibsagar Revenue Circle passed the order and grant mutation in the name of the present answering respondent for a plot of land measuring 14 lesas. Now that has been annexed as annexer, page 14 of his affidavit. So whether petitioner has and LCR has come. And who are the council?
Councils have also changed hands. In fact, I have got PJ Saikar in the morning. So he told that he has
He's no longer there.
no longer with the brief. So he has handed it over.
If Mr. Burua, we
Yes.
can list it tomorrow. If it is not found, because these are 2016 matters.
Yes.
If it is infractions already by the time it was filed, LCR is available.
There is no
Go through the records, then we will dismiss from non-prosecution.
Yes.
If he comes, we will revive.
Yes.
Otherwise, no point.
There is no point keeping.
Mr. There is no representation on behalf of the petitioner today on call. So stop. Mr. Borua has learned junior government advocate Assam for appearing for the state respondent has submitted that it appears prima facie that the petition has become infractious in view of the order already passed by the mutation order already passed by the circle officer Sibsagar Revenue Circle on 3/10/2015. So he has, however, submitted that he will go through the case records of mutation case number 146/15-16 to assert in the same. Post up. List the case tomorrow. You go through tomorrow morning. If it is already dead by the time repetition was filed, no point. I think that is why they are not interested.
It seems so.
Keeping us busy.
Yes.